My lords, we are praying for
There's
similar
just
relief.
one. There's just one. Sorry.
SLP. Gopi Krishna matter is pending, right?
My
Yes.
lords, in fact, there's an interim order also Your Lordship has passed, directing them to deposit 50% of the amount claimed.
There's just one request on this, Manoj, and that is this, Manoj, that in the present matter, all amounts had been paid to them and they had given no due certificate, etc. Manoj. So nothing is due, nothing is withheld.
1 minute.
Nothing is withheld.
What to do? To file a counter so far as the interim are concerned.
May I just submit one
If it
thing?
is necessary, then we will.
May I just one. At page 218.
All payments are made.
No,
This certificate is with
that's
us,
the dispute.
no
But
dues.
218 in the writ petition, I have specifically given the statement which amount which has been withheld. Page 218, my lords. So that is already there. That's the dispute between the parties.
Say that if any amounts are still pending.
So Lordship may indicate if any and then have the same order. Suppose say if they believe there is not, so it's a different thing. We'll then file our appropriate.
The pending disposal of the special petition, if any amounts are pending, the same shall be released to the respondent.
50%, Lord.
50% of are any pending. Okay, then you say that Mr. Rakesh Devi, learned senior counsel, submits that no amounts are pending.
Withheld.
No withheld by us.
No amount has been, which is, which statement is disputed by Mr. Devashish Paruka, senior counsel. We make it clear if any amount lesser than 50% is still pending, the same shall be released without any delay.
To be deposited in the registry. As per the law.
Your Lordship directed it to be deposited in the registry.
Shall be deposited in the registry.
Grateful.
They will dispute, we know that. They will dispute it.
Item 3, may please, Your Lordships, my lord. My lord, two important, my lord, questions of law arise, my lord. One is
Treating scrapped asset.
Yes,
is
my
one
lord.
thing, and pension contribution
Absolutely,
is the
my
second one. Conditions. The pending matter is different, but the APTEL says that contents of the pending matters are very different. We don't know.
my lord, that is a my lord writ petition filed by the workers' union, my lord, seeking a writ of mandamus, my lord, directing the government to fund the shortfall in the pension trust. My lord, that has got nothing to do with my contribution. Grateful, man.
Yes.
Obliged.
So,
My lords, I'm requesting for a short pass over, my lords.
ex-employees, the similar matters
Yes, fathers.
want you to.
The
Similar
two are
matters are there.
Yes, my lords, 4 and 4.1 are similar matters.
Notice.
My lords,
What's the
short pass over, my lords, the senior is just coming, my lords.
What is similar matters are
No,
there.
no, no, these are two connected
There is a
matters.
question of
These are
Two
two
connected
connected
matters,
matters,
my lords,
that
4
are
and
listed
4.1.
today. They are not connected to any other matter, my lords.
These are connected to each other.
These are
Doesn't
challenging. These are challenging a resolution plan approval order. My lords, just grant a short pass over. We want to make two submissions, my lords.
Alright.
Just give us a short pass over, my
We
lords.
should-
I'm grateful, my lords.
Great.
Item 5.
So, what is it that can be done? Adjournment order.
Milords, connected matter.
Adjournment order, Mr. Shukla.
Yes, Milords, a connected matter has been
September
previously.
26, your regular appeal is listed on 26 September.
Indeed, Milords. Milords, a connected matter has already been decided by this honorable court, and I'm humbly just requesting to withdraw this matter.
Dismissed.
Milords, I'm just
Withdrawn,
requesting
withdrawn.
permission.
Item 7. Item 6.
Manoj, in this merge the High Court. Manoj, I'm agreed only by para 7.
It's been reported.
Similar matter.
Reported, no? Similar matters are there.
Similar matter with that.
Same notice. As against the suspect order, SLPs are pending.
Milords.
Not against this order.
That's good.
Issue notice post along with so and so.
Obliged.
Item 7.
Lord, item 7, I have my lord. The lordships had given us liberty to come back, my lord, in case my review, my lord, is rejected. Now, my lord, the point, my lord, we had raised was, my lord, in opposition to the section 11, that is clearly time barred, my lord. And my lord, that was taken not only in my objection to section 11, but also in my written submissions, my lord. My lord, I can just refer to the dates, are very clear, my lord. If your lordship sees section 21, notice is 2019. And my lord, the section 11 petition is filed in March of 2025.
send it to the single issue exam, whether we have a. Can have the power.
So, my lord, your lordship knows the distinction, my lord, whether where the section 11 is time barred to where the claims are time barred. So the learned arbitrator says, my lord, this is the issue raised by is that the section 11 is time barred, which I have no jurisdiction, which is correct, my lord. Which is correct. I don't think, my lord, that he is wrong in saying that. So the section 11 court should have decided this, my lord.
Notice.
My lord, may I respectfully submit only pleadings are complete, my lord. Let them not proceed with the arbitration, my lord.
Doesn't matter, take out dusty, will come back.
Oh, very well, my lord. Returnable date, my lord.
Yes, 2 weeks after.
Lordship,
After 4 हफ्ते के बाद ये आ जाएगा.
That's right. Very well.
Item 8. Sir, relied upon order is under the challenge, my lord. The question is whether TDS, my lord, without even being made, can it be given credit?
Similar matters are there.
Yes, my lord.
Notice.
32998 of 24.
Notice post along with that.
SLP diary 329.
We'll do that, Vartana.
Yes.
Item 9 and 59.
My lord,
What is this delay?
in item number 9, there is delay of
206 days.
May it please, my lords, I'm
Unexcusable.
appearing, my lords.
We were wondering why.
My
you
lords,
are-
these matters are coming up on Monday, my lords. These are NANA matters. There are 2-3 matters which can be detagged. I'll just give a chart and I'll explain, my lords. In item 9, only 9.6 is a different matter, invalid pension, that can be detagged and listed separately with the another batch. Otherwise, all our NANA matters, they can just be posted along with the NANA batch on Monday, my lords.
9.6 and 59.5.
ठीक है,
They have to be listed with AK Thapas, my lords.
58.5. Okay, give us the list.
Yes, my lords. There's one matter which can be dismissed, my lords. 59.3, disposed of in peculiar circumstances. This is an injury case. We are not pressing, my lords.
59.3 we discuss कर लेना simply. Then
59.4
all
has
others
to be
will-
listed.
all others will go with Nana batch.
No, my lords. 59.4 has to be separated.
Scholars will, huh?
Yes. That can be listed at any other occasion. We will argue, my lords. And 59.5 is an invalid pension. My
Okay.
associate is there.
You follow
She
it
will
up.
give the chart.
That is
Yes,
the first
I'm
part.
grateful, my I'm grateful, my lords.
Item 10.
Much obliged, ma'am.
Okay, and item 10, my lord, kindly see the
All
it is a recall order, my lord. The High Court refused to entertain, my lord. Actually, there is no.
how many forums will you lose continuously? This will answer shipping charges.
Please.
For failure to deduct TDS, that obligation arises. If you don't deduct TDS, then the consequences are natural. Dismissed.
But the lordship may condone the delay in 5 minutes.
They condone necessary.
Highly the
The batch of matters
Yes,
are
yes.
pending.
Multiple show cause notices.
Yes.
Well,
Wait.
Your Lordship, I request for a short adjournment today. Mr. Manan Mishra will be leading in this matter. I request Lordship for next week. Adjournment, Lordship.
why?
Mr. Manan Mishra will be leading. He's under some personal difficulties.
I'm sorry, Your Lordship, I should have been here. Mr. Manan Kumar Mishra is to appear in this matter just last night informed he's in some difficulty. Have it on Monday also, Your Lordship.
Not Monday. No,
Any day convenient, Your Lordship. I'm sorry, Your Lordship, we couldn't circulate it.
circulated a letter.
I'm sorry, Your Lordship, only last night we were informed he's perhaps unwell.
Don't take senior advocates' names like that.
I'm sorry, Your
You
Lordship.
ask for an adjournment, that's good enough. Just
I apologize, Your Lordship.
advocates' names. I mean,
I apologize, Your
accommodate you, but then next call the next day.
I apologize, Your Lordship.
Confirm.
Wait, please, Your Lordship. Here, Your Lordship, we are concerned with the compensation of victim because neither the Act 2024 nor the amendment of the bill has taken care of that. It's only a quantum of punishment of criminal prosecution. But the victim's interest.
There is nothing remaining in this.
Compensation victim has been left out, Your Lordship.
Findings are very clear. The award is set aside for clear reasons.
No. This is valid. Correcting Your Lordship.
Yeah, we saw. Now you know.
Your Lordship, here we are interested in the compensation of victim, Your Lordship. That is not been taken care of by the Act, nor by the subsequent amendment of this bill, Your Lordship.
Sorry. 14. Would have had a hint of what it was.
Sorry.
Right.
Because here we're requesting, it's a fresh matter, and we're requesting notice and consideration because there's lots of issues. There's a unanimous arbitration award after reducing evidence in my favor. That unanimous award was in two parts. First, it granted me approximately 62.86 crores of rupees after reducing and considering the evidence in my favor, and it rejected the counterclaim which was filed by the respondent over here.
We saw that, but
Yes.
then it's not as if the 34 judgment is without any reasons.
No, I'll take your lordship to the section 34 reasoning, the 34 reasoning. So I'll take you to it. So first, Manoj, just take up. First, let me give you a little background about what happened over here in the case.
Sure.
Because the first issue which happened was that there was an incident which occurred, and your lordship may note that date on 31st August 2019.
31st August, water
31st
tunnel. Water tunnel.
Yes, so there was a huge unexpected, because there was a clause in the particular agreement also which said that if there is something which cannot be reasonably anticipated, and if work has to be done with respect to that particular work, that additional work, then you are entitled to recompensation. That is the broad scheme insofar as the agreement is concerned. So this incident took place on the 31st August 2019, where there was a sudden inflow of water mixed with mud. Now that resulted in the tunnel boring machine, etc., the TBM, etc., sinking. So, sorry?
No,
yes. So experts had to be brought about for 2-3 things. One was, there was obviously the question of safety above. So the second is that the TBW itself had to be retrieved, and it had to be ensured that there is no danger, because life is the most important thing, but also with respect to property, because there were buildings, etc. Now, for that purpose, additional expenses were incurred. Now, we were required to establish before the authority, before the tribunal.
Sorry. The court seems to have been troubled about accepting that IIT
Madras.
Report.
Yeah. So, no. So I'll just tell you. So just give the table. So I'm just going to take you straight away to that. There are a series of reports, because what the tribunal did was that both the parties agreed that we will go on, because it was what, just please keep something in mind for the constitution of the tribunal. At that time, one party could suggest that constitution of the tribunal. So they gave 8 names, out of which we selected one person. They were all engineers of tremendous experience. And therefore, I emphasize that it was a unanimous award which was passed over here. Now, sorry, so progressing on. So, Manoj, the parties agreed that our parties would, the case would be decided on documents. And just please go to page 450. The award itself is annexure P8, page 435. Please directly, that's where it starts. Page 435.
435.
Yes. And go directly to 450 at this point. Your Lordship, sir, para 19. May I place it?
Yes.
And whereas this is the recital to the award, the claimants commenced examination of its witnesses by filing an affidavit of evidence, and subsequent thereof, the respondents commenced cross-examination. However, in the sitting on 12th August 2022, the parties decided to dispense with the oral evidence, and the following orders were passed. Formal proof of all documents is dispensed with. Contents of all documents which have not been admitted would be a subject matter of arguments. In all cases, the arbitral tribunal would decide the probative value of the contents of all documents. The affidavit of evidence and his depositions, which have been recorded, be expunged. So the parties decided that, look, I had my expert reports, they had their expert reports, and we left it to the arbitral tribunal to decide.
dealt with 4.1.
4 point. Yes. So I'll just explain to you first. Absolutely. So can I just tell your audience as to what happened and the conclusion and then. So we had experts. We had 5 expert reports. Just note them. I'll take you to those pages. The 5 expert reports which we placed, 2 were by GeoConsult India Private Limited. Just note, GeoConsult India Private Limited. Another was by Charles Mann, MANN. A third was by Surbanga Jurong Consultants Pte Limited. And a 4th report was by Heron Nest India Private Limited. Now, all these people, sorry?
Go ahead, go ahead.
Yeah, now all these people visited the site. They gave their expert opinion. And what was the expert opinion on? The expert opinion was that this rush of water and mud mixed up could not have been reasonably anticipated in the facts and circumstances. That was the essence of the report, because that is the circumstance which entitled me to make an additional recovery. So all of them said this particular thing. The other side did not furnish reports of anyone who was contemporaneously present. Months after, so first just keep one thing in mind. IIT Madras filed an affidavit and a report in a PIL, which was a separate proceeding, that was also adduced in evidence. They said in the PIL, IIT Madras said that yes, this could not have been anticipated, etc. It's whatever act of God, etc., could not have been. In the PIL. Many months after the incident, the respondent furnished photographs to the IIT Madras. The IIT Madras in a disclaimer said that these photographs are not very clear.
How are we to get into all this?
So your lordships are not, because your lordships are not to get into it, because the arbitral tribunal has got into it. Now just give the table. Now, sorry, please see the table. Please see the table. They have gone into it in every detail. They have gone into, just have a look at the table I've given you. They have, this is exactly the point which we are making. Yes. Please just see now. Findings recorded by the arbitral tribunal on the reports of the petitioner. Report dated 8th October 2019, issued by Charles Mann, independent assessor. The arbitral tribunal at paragraph 101 at 495 considers the scope of the report, that is the assessment collapse of the tunnel on 31st August 2019, examination of material carried out by the expert, and conclusions arrived at by him, which inter alia states there was nothing to disprove that the TBM hit a large body that was unexpected and unforeseen during the TBM excavations. Next, report of 9th October 2019 and 16th November 2020, issued by GeoConsult. The arbitral tribunal in paragraph 102 at pages 496 to 499 notes that GeoConsult was present at the site on 16 September 2019. The tribunal further notes that the expert had relied upon research articles and based its conclusions on materials elaborated in para 101b. The tribunal also notes that observations made by the expert as well as the conclusion that such grave incidents are not foreseeable in the regular and diligent working. Then you have similarly a report of Subranga Jurong Consultants Private Limited, which is in my favor. I'm confining myself to the italicized portion. Prepared from the designer's perspective for the possible causes of the incident, subject to actual cause, to be verified upon recovery of TBM1, based on the damage that CP shown for the TBM and indicate that the excavation is well controlled. Based on this report, the expert concluded, inter alia, that the incident might be due to unforeseen conditions. And then it goes on, where there is a further report of this Heron Nest. Now, after that, at page 3, they have our tribunal dealt with each and every report, expert report prepared by the other side. Now see their answer. Please see, your lordship will go to page 3 of the table I've given. Reports obtained before invoking arbitration during the pendency of the PIL before the High Court. So this was earlier. Report of 13 December 2019, issued by the expert committee headed by John Endicott. The arbitral tribunal at so-and-so examines the report in detail and notes inter alia.
Much of it depended on.
Yes. Sorry.
Much of it depended on whether it could have been expected or not.
Yes. Now they applied the preponderance of probability. Sorry. The arbitral. Look at the standard the arbitral tribunal applied. Just have a look at that. It's the absolutely correct civil standard, which is civil in civil law. Please go directly to page 525. Para 1. It's a very, very detailed arbitral award, and it's a unanimous arbitral award, which looks at each
preposterous award.
Sorry, no, but just see this correct legal standard applied. Page 525, para 121, para 121, and I've got several other points, but I'm just emphasizing. Please just, Your Lordship has para 121. Yes. Can I just now place how the correct legal standard has been applied? I'm reading 121. A lot of theories and opinions will keep on emerging as we go deeper and deeper into the micro issues. Sorry. I'm just reading the fourth line in para 121. We are here to judge the issues from an engineering point of view. Engineering is not a piece of science, but an applied science with a lot of design constants and coefficients derived based on past experience. It is possible that after the present incident also, some of the coefficients and constants could stand modified, like the additional modifications carried out while carrying out the work over the incident. However, these are just preponderance of probabilities with improvements to cover any unforeseeable physical condition. Engineering involves constantly for having a healthy mix of theory and ground experience. These improvements have no end, and no one can be sure of these improvements could have contributed to the safe passage of TBM2 or were just superfluous additional safeguards. None of these theories can put a definite blame on the claimant's conduct on the date of the accident. Thus, unforeseeable physical conditions in terms of condition 4.23 of the general conditions of contract on the day of the incident appears to be a plausible assessment to the entire incident. The case of the claimant is accordingly allowed. So preponderance of probability on the basis of all these materials, and it goes on further. Now just see two parts. Please go straight away to page 539. Page 539. Now, in respect of each item, where's the summary? In fact, Your Lordships, instead of 539, they deal with each item, but perhaps Your Lordships can go straight away to 548. 548. That may be quicker. Your Lordship has 548? Your Lordship has 548?
If you have argued this factual situation depending on the multiple reports.
Yes.
Threadbare. In fact, the DB judgment.
My report, yes,
rejected,
absolutely.
My report rejected. Contested. So what will the court do?
No, but that is precisely my point. Just a minute now. That is precisely the point. Once you have a thorough examination by the arbitral tribunal which renders a unanimous award. Now the unanimous award is twofold. First, please just see the summary of claims allowed at page 548, and Your Lordship will go straight away to the figure of 6, obviously substantially disallowed, 2. The total there, you will find the figure about halfway through the page, 62 crores, 86 lakhs. Your Lordship has that? 62, 86, 72, 29.
Got that.
Your Lordship has that. Now see the discussion. Now I'm on a separate issue. Now go to page 554.
Error in 34. Show us when
34. There is absolutely no error. Sorry. Sorry?
He meant award. What we were.
No, the 34 error is the High Court has. Sorry.
In 37 is also, again, you seem to have pressed the same thing. And the
no, but 37 just doesn't, there's no independent reasoning at all in 37.
Examined very closely, Mr. Diwan.
Sorry?
It is very closely examined. It's not just one line order that 37, we don't need to interfere.
No, it is. I'll take you to 30. So first I'm answering your Lordship's point. Please go straight away to page 554. Page 554. Counterclaims of the respondent. Your Lordship says, what are the infirmities, etc. First, let's start with page 54 to show the whole approach is atrocious. Your Lordship has page 554. Now, please see para 145 onwards. Counterclaim. Discuss, just see pages after pages of every counterclaim taken separately, discussed, and thereafter, Your Lordship may just go to page 564, where they have a summary table and they reject all the counterclaims. Now, without one line of reasoning in the section 34 order, one line of reasoning, this part of the award is also set aside. How is that possible? Not one line of reasoning. There are separate issues. There are separate issues here. There is the claim which I am going to satisfy Your Lordship was fully discussed by the arbitral tribunal, and the 34 court had no business to be poking its nose in over here.
Thank you, Mr.
Now, But counterclaim, there's not one line of reasoning.
Look at what is happening. I'm Kolkata Metro, I see for a debate.
I would like your lordships to just have a look at the 34 court. Look at the 34 court. This is
You've seen that,
upsetting.
Mr. Diwan. You've seen that, Mr. Diwan.
No, please just see.
We have very carefully seen because.
So may I tell you what the grounds of the 34 court are? One ground is that it says that the engineers brought their personal knowledge. Now that's completely incorrect. That's factually incorrect.
They have dealt with the context in which the IIT report was ignored.
So I am answering the IIT report. Now let me answer the IIT report. Let me deal with it. The IIT report was not based on an inspection which IIT carried out. They were not based on an inspection. The IIT had made an actually. Please see that.
Reports come.
You please just see that. How can the IIT report be even have any credibility? Please just go to my table. Just go to this table. They dealt with it. If awards like this, my lords, which are so meticulous and detailed and unanimous, are interfered with under Section 34, then we are driving a coach and forth through the whole scheme of the Arbitration Act. Please go to page 3.
Not so common.
Not rare.
What do you say 1 minute? What do you say about the counterclaim?
That's one. I want to finish this. I want to satisfy your lordships on this IIT. IIT, please just go to page 3, serial number 2, IIT Madras. That's your lordship's question. Report dated 31/1/2020.
Up your note.
Yes, just this note, just to summarize it, otherwise too many places. Report dated 31st January 2020, issued by IIT Madras.
This John Endicott's report.
Sorry? I'll just place it, serial number 2.
John Endicott's report.
Yeah. Now, the arbitral tribunal examines the report in para 107 at pages 505 to 506 and notes that the report reviewed with John Endicott reports. The arbitral tribunal notes that the representatives of IIT Madras had visited the site on 18 January 2020 and that the conclusion of the report revealed that certain additional works were required for resumption of the work. Now, please go on. A report of 24 January 2022. Arbitral tribunal, this is words of IEST Shippool. The arbitral tribunal examines this report at paragraph 108. The arbitral tribunal notes, as admitted by the respondent in its counterclaim, this report was prepared to defend claims made by the claimant. Therefore, this raises an independence of the evidentiary value of the report. Now, this is entirely left. Now, please see the IIT serial number 5. Just a minute. The IIT report you are looking at was serial number 5. Serial number 5 at page 5. The arbitral tribunal examines the report dated 17 February 2022. The tribunal notes that on the perusal of the introduction, it appears that this is not an independent report. Consultants of IIT Madras studied the geological conditions while the TBM aspects were examined by Dr. G.J. Page. Therefore, it's a combination of two reports. The tribunal notes that the report was prepared solely for the purpose of defending the stand of the respondent as admitted. It's further noted inter alia that IIT Madras had itself stated that the report was prepared on the basis of data supplied and photographs from the daily report of the TBM retrieval. Even though IIT had relied upon photographs, it has stated that the quality of the photographic evidence cannot guarantee the accuracy of comments.
This concluded now. In a few minutes, conclude, please.
No, so I'm just saying, your lordships ought to ordinarily, when there is a unanimous.
We have seen it's
yes,
not usual that arbitral awards are.
No, but just there has to be
satisfy the bestowed.
Please see, there has to be some basis for setting it aside. Can the basis be that they have not examined the report? Amount of evidence, quality of evidence, and the amount each report is considered by both the arbitral tribunal considers my reports and there. Then comes to the conclusion there are preponderant because this could not be anticipated. They eventually examine the merits.
That relates so much to the credibility and inference on the basis of findings given in each of those reports.
The arbitral tribunal the arbitral tribunal on the amount of evidence.
That's the same point. We understand. The point is that once the arbitrator.
This is not a case of no, sorry.
Cases and cases.
It's a case of rejection.
This is not a case of
this is not a case of no evidence,
yes.
but there are very closely given 6-7 reports on
right,
all that.
Yes. and we look at it.
No, they don't look. My reports are rejected.
Please see.
My report is
A party, in an arbitration.
my report is said is not in independent
evidence. Because a party has to.
Of course, we're going to ask you, but relaxing. Just wait for a minute.
Yes.
Mr. Divan, I think you made your point.
No, I just want to say I want to classify this into
You made your point. We understand this. This is a beaten batter so far as arbitration is
All
concerned.
right. Now, if that is the case, if that's the case, then the question, as I understand it, for a 34 court is: was this evidence placed before them and considered? The answer is yes. Was it weighed? The answer is yes. What the tribunal does eventually, because these were engineering experts from a panel of 8, which they suggested. Out of that panel of 8, I selected one.
34 and 37 court which have done when an
Now look at
arbitration
37 court. Now,
objections are raised. We will not be
No,
doing
now,
something more.
apart from that,
It will be a third court which will again reconsider these things.
No, but now look at the impugned judgment. Look at the impugned judgment. There's any independent consideration. Look at the impugned judgment. There's no independent consideration at all. Just have a look at it. Please go. Please go to page 23.
You've seen that.
Please go. The impugned judgment also noted relevant clauses. Your Lordship has that? Page 23.
Yeah.
Then, after note that para 28, after noting the aforesaid clause of the contract, the learned single judge observed. Then they set out Sangyong, engineering. Then, para 31, it should be noted that the arbitral tribunal not only overlooked the terms of the contract, but also ignored without assigning any reason. Where is the independent consideration under the 37 court? Look at para 33. We have noted here in above that the contract between the parties required the contractor to report in writing an unforeseen physical condition. No evidence of such report has been brought
We'll ask him.
No, now, final point. Factual. They have now reinitiated counterclaim.
Because that was not before the same tribunal.
Set aside.
Before the same tribunal.
No, it won't be the same tribunal. They have filed a section 11.
That's okay, bro. That's
not one line.
Okay, tell us. No, that's a new fact which we have not heard.
Sorry?
That's a new fact which we don't know.
Yes, that's exactly why I thought I should tell you. They have now initiated, because you see, if it has been set aside on the basis that the arbitral tribunal has proceeded contrary, etc., it may be possible for parties to restart the arbitration. But not the party seeking a counterclaim, because there is not one line of reasoning in the
relevant here, but
it's absolutely relevant, because you can't, the award is comprehensive.
Is your contention that the claims raised in the counterclaim are identical to this?
No, my answer is this. My answer number one is that the single judge under 34, at least that's my understanding of the law, that you can't set aside a rejection of counterclaim without one line of reasoning. You have to consider where the arbitral tribunal went wrong. Not one line confirmed in by the appellate court under 37. So that whole matter of 34 has attained finality, according to me, in my favor, because the counterclaim rejection has not been set aside in a cogent manner known to law by either the single judge or the division bench. That's one argument.
What is it that they have now did with respect to the
They've initiated for the same whatever counterclaims that they have.
That is
but that will go right.
That's good, but
we can't set aside that clear, right?
You see, they are relying on the fact that the award has been set aside in toto.
Yes.
They are relying on the fact the award has been set aside in toto to restart arbitration against me. Now, my respectful submission is that regarding their
one minute. The legality and validity of a subsequent arbitration will be judged in that.
So, therefore, to buttress my case, but unless this, to buttress my case, I want to say that the setting aside of that, they tried the counterclaim. It was rejected on merits. Sorry,
Mr. Divan, was a section 11 allowed by the High Court?
No, that's pending.
It is not even filed. I don't know what he is talking about. It's not even filed.
1 minute, we are not very clear.
Okay,
one minute, we will ask you. With respect to the counterclaim finding given by the arbitral tribunal leading to 34 and 37, have they initiated a new arbitration by filing a section 11 with respect to the counterclaim?
Because they served us with a notice.
What do you want?
What I'm requesting now I'm requesting for a full-fledged notice to be issued over here. because this is a matter which requires consideration. When in our respectful submission, arbitral tribunals like this, the section 34 looks at it and says, sorry, I don't want to.
We are on the point of you again mixing up issue. We are on the point that about counterclaim issue.
Counterclaim has attained finality before the tribunal. The only way it could have been reopened is if you had reasoning in the section 34 judgment, upsetting the 34. There is no reasoning.
We agree with you.
Fair enough. So therefore, that ought to be in my. How can he say that? How can the 34?
I must get some
chance. See, there are two parts to the arbitral award. There are two parts to it. The one is, as far as my claim allowed is concerned. The second part is rejection of counterclaim. On the rejection of counterclaim, there was no warrant for interference and there was no justification for interference, and therefore in setting aside the whole award, the 34 court was wrong, and in confirming this.
What is the finding with respect to counterclaim?
There is none. That's the
That's the point. So
the award is set aside. It goes
on the same ground, my friend.
How can it?
Sorry, Mr. Diwan.
Absolutely.
Okay, tell us. Now we have heard you.
But I would not able to.
Can I just ask me?
But I just want to know, man. I just
so far as your
situation.
tell us
about your chance now. Allow me 5 minutes.
I would urge your lordships, just consider, just sit back. I mean, just go back for a moment. This is a huge contest. Just think about it. There's a contested arbitration with a panel of 3 engineers.
How many times did my friend say this?
Who look into the matter.
Unanimous.
Okay, it's a highly contested matter, so therefore he's entitled to what's wrong.
Yeah.
Now the question I ask myself is, what is the scope of interference under 30? Has there been some procedural impropriety? There has been none. It's an evaluation of evidence and an interpretation of that clause where they come to the conclusion that this could not be anticipated. If a party could not anticipate.
You're coming back to the same point, Mr.
Now, Lord, according to me, this is the height of diversity in this award. No amount of unanimity cannot remove poverty. Let's first understand what the facts are. He hasn't told you the fact. A tunnel is being built under the busiest part of capital. I am Kolkata Metro Rail. I have to use a train. Contract was given to him. He brought a tunnel boring machine, TBM. The machine. That TBM, on account of faulty use, collapsed. When the TBM collapsed because of water inflow, the surrounding roof, that is the road, the locality, collapsed. Large number of buildings.
That we have seen, that those are facts. Tell us about the credibility of IIT.
So now what happened was, it took 3 years for the parts of the TBM report to be extracted. It is we who have suffered immense losses on account of a debacle caused by this man, and he has a temerity to file a claim against Kolkata Metro for his faulty use of the machine. Machine broke and there is a collapse. It was catastrophic. So, when we appointed 2 government agencies, one is IIT Madras and the second one is called Indian Institute of Engineering in Science, Government of India. So, one report has gone and said, we have examined the soil. His case was, the soil was such that it became like a wish measure and the whole thing fell. That report said that there is no difference in soil of this area and the surrounding area. So your entire story of this major and all that is all bunk up. Number 2, IIT Madras also said that the use of the machine was
for 10 years. It took 9 years after the agreement was executed for the occurring of the incident.
I am suffered. Now, all the reports placed, see how the tribunal chucks it out. Kindly turn to 507. We come to 34 later. This is one of the rare cases where both the courts have set aside this perverse award. 507, para 108. 507. Once the lordships have it, I will show.
Yes, only one photo. That's IIT report.
No, blood. This is Indian Institute of Engineering in Science, 108, blood. It's a different report of a government institute. Just say Radhe has it, blood, I will read it. This report pertains to analysis of soil sample and review of pre and post incident geotechnical investigation reports in the retrieval shaft location. Disturbed samples were given, object was this, that, and the other. Para 5 of the report, investigators restricted to 4 disturbed samples, so and so. Consultants have concluded revealed from all exploration reports combined that the soil available at the tunnel level are predominantly sandy, etc. On the next page. Lord F.
Very
key.
well.
However, as per written note of arguments, the respondent has made a statement against counterclaim. The respondent, for purpose of defending the claim made by the claimant for effective adjudication and assistance also, apart from independent expert, the respondent.
The finding we saw that just before 109.
I just want to read that. This report is one such listed report as per statement. It is not an independent report and prepared at the commencement of the case for sole purpose of defending the case.
That's what the 34. That's what the 34 court says.
So now we not see the second one. Is error is repeated right now, sir. 109 IITM is IIT Madras. Nobody can raise a finger at IIT Madras. It goes on the same way. My lord turns to subclause D on the next page.
EE.
This is not an independent report and prepared subsequent to commencement of the case for sole purpose. What should happen? The whole thing fell down. You took 3 years to extract it. I have to get people to examine. If you, my lord, shut out this evidence, you have the temerity, my lord, to raise a claim.
And his evidence is all pre-retrieval evidence.
And if this is the state of affairs, my lord, I gave 3 reports, these 2 government, now on counterclaim.
This is exactly the competing claims on the basis of the multiple reports that we will need to be.
These are findings of fact, where my evidence is chucked out. Now, look at the basic fact. A man who's guilty of this debacle, my lord, bought 60 crore rupees from the Calcutta Metro. What have I done? What have I done? I should pay him 60. And my lord, when you grant wrongly to him, then my counterclaim has to go on the same reasoning. Whether I can do it again, not again, not something matter here. Kolkata Metro has suffered immensely from a perverse award. And the second finding is
the other serious contention that he has is that his award as it is set aside lock, stock and barrel.
Yeah.
According to him.
It has to.
So it takes within its sweep as if there is no finding anything at all with respect to the counterclaim. So
that's not true.
So
that's
therefore,
not true.
So is that?
Yes. That is not true.
The ground for rejection of counterclaim.
The ground for rejection, not 556 below. 556. The equally perverse. 556 below, third line from top. It is printed in bold below.
But that's what the point he makes is that yes, arbitrator talked about it, but when the award is set aside, it is as if this whole thing has gone and given you a new fresh life.
New fresh is not before this court. It will be decided by some court if I go there. Question is, if somebody gives him 1 rupee, it can't give me 1 rupee, my lord. Either he has it or I have it. It can't go both ways. It can't be that his claims are below.
Subsequent arbitration could be barred.
That's not before here.
That's not before us. That's right. It could be barred. Because there is a clelear finding with respect
to just have a look at this.
Counterclaim by the arbitral tribunal.
I'm showing
you. So the counterclaims are allowed on the basis of Salford.
I'm just seeing it. 556.
He is right to that extent.
556. 556. Third line.
Yes.
Your lordship will find the physical condition. Third line. At the tunneling location leading to the incident would not be foreseen by the GC and the respondent. It is indicate that condition was unforeseeable. This is the basic point. He says, oh, it was a mismeasure. I said it's all wrong. The report said that you knew everything. Now, my lord, see further. It only indicates condition unforeseeable. Since this is the central issue of the arbitration on both sides, and same is not substantiated in the argument or record, the counterclaim shall be decided on this ground largely. That, my lord, if the central issue is this, what was the point of this counterclaim? It's like 7-11, chucked out because of this reasoning. What happens in future, my lord, is something different.
Okay, we'll leave it at that, Mr. Divan.
Thank you. Requesting the section 34 what has no line of reasoning for it's not a question of later on. That how will the later on court, if your lordships do not interfere in the counterclaim?
Shall we say that so far as the findings related to
Kindly,
counterclaim,
sir.
this will have no bearing, the decision here will have no bearing in any subsequent.
right.
We can make an
Lordship has said
observation to that effect.
Your Lordship will say, with
No, tell us.
appropriate order to say that the single judge has not considered the counter.
No, I'm sorry, Lord. That's not correct.
If a award and a whole is set aside,
I'm sorry,
it comes up to the Supreme Court,
We are not.
and you don't.
This can't be, Lord. It cannot
We
be.
will not say anything. We will say we are not.
The Lordship may just leave it at this point, really speaking.
Raised an issue with respect to the method, with respect to the way in which the counterclaim issue has been considered in section 34 and 37. In view of the fact that we express no opinion, all grounds and contentions are kept open to be raised and contested.
Can I just, Your Lordship, press the full case? So, Your Lordship, I am not, this order will read as if I am only pressing for counter.
No, we are not. Then we will say that. Then we will simply dismiss it.
I am urging the.
You heard you.
It can't go like this.
You heard you. You heard
See
you.
what happens. Now I'm only on
Again and again, my friend.
I'm only on the counter.
Today.
This is
The counterclaim part, there's not one line of reasoning why that part of the order is set aside by the
See,
single judge on the
accountability
bench.
is an important thing, Mr. Diwan. We have applied. It's not
No,
only
I'm
in the
saying
morning.
that it will restart. Why should it restart when it's not been set aside?
Mr. Diwan, thank you.
Very well, grateful.
15.
No, not that.
15, who is appearing?
Unpaid population. I don't see the pure.
What is this, Manisha?
Sorry, Milord?
What is this issue?
It's the pure contractual dispute in which the court has gone into the writ jurisdiction. It was purely a contractual dispute, my lords, with the.
Wait, anyway, you have admitted all these amounts.
The issue is here about the 3 guards also. That amount not been admitted, my lords. It seems, in both the sides, there's been at one side, we are punishing our officers. The other side, the contractor, who's also been at default, has been awarded this amount.
Para 22 of the impugned order. No. Para 22 of the impugned order, there is a finding recorded by the High Court that your Deputy Commissioner has admitted that a bill of 5 crores 18 lakhs and odd rupees is pending. And you are trying to adjust the amount of tree guards which have been stolen. So that's what High Court has said. It is your responsibility. The fact that tree guards were supplied is not disputed by you. So at least to the admitted extent, the amount which is due should be released. What is why he should be driven to remedy of
the reasoning? The decision is not because of the reasoning; it's because of your admission.
The amount, look at the amount that
You can't get over that.
was 27 CR, my lord, already paid. And the guard.
That's happening too often with the.
The 3 guards are still with them. As far as those 3 guards, we should. My lord, comment for.
Okay.
6, my lord.
Have you taken any action against those officers? Have you dismissed it? Where? You place on record, we'll see. You place on record those. You just adjourn it. You show us that. It's not simply that you admit the payment of some money and later on. What action what inquiry have you initiated?
The inquiry has been initiated against.
First.
Inquiry report is there, my lord. Page.
Madam, is it your case that the tree guards have not been supplied at all?
Clean.
My lord, some of them, like 1,700, more than 1,700 were stolen, my lord.
Quantum.
And the complaint has been lodged by us, not by the contractor. It was.
If they have been stolen, how the contractor can be held responsible? Was he responsible under the contract?
Yes, ma'am.
That if it is stolen, then you will.
He was getting paid for even deputy the guard for it.
This you have not argued at the high court that he was responsible.
Clause 13, 22 and 7. My lords, please also note the fact that 5,810, they have not even installed those tree guards, my lords. That's the case, my lords. That's a factual.
In your report, did you talk about all this? Is there a proper report on this?
Yes, my lord. There is 107, page 107.
Let us see what is the.
There is an inquiry report. Legislative Assembly start question number so and so regarding alleged irregularities in the work of the tree implantation. After the proper inquiry was conducted, then this is an inspection report start at page 109, my lord.
What to people out of it?
We come to page 113. As per the tender condition 4, a general provision has been made, and then to the high.
No. Contents is very different. Tender process implementation of the project.
Well, High Court also observes that.
Supply of the tree card?
Norms.
Is there anything like that? Then it's only talking about whether the necessary requirements were actually verified or not verified.
That's what
Show somewhere.
Question, my lord.
Show somewhere.
Come to page 122.
Whether the total project was cost
All
was
of the
reasonable.
above accrued rates
It's about the cost.
also,
There's
when
nothing.
the jurisdiction of the municipal corporation total 298
Status of the number of
98,000 trees have been reportedly been planted under the present project. Now, after that, in addition, the amount released and even starts at beginning of page 122. The maximum number of is that 16,447 tree guards were reported stolen from the jurisdiction of the award committee, which the objection will further the fact that large-scale theft of a tree guards occurred after the payment was given.
No finding there.
Short point is not how the input tax credit wrongly taken would be the interest would be payable. The answer your lordship would get at page 34, rule 88B3. Page 34.
Input tax credit is
B3 minute.
No, so you have wrongly availed input tax credit for 630 days, right?
That is what the department says. It has to be calculated. Twice I have utilized it. One was 13 lakhs for 90 days and 32 lakhs for 30 days. And this is permissible at page 34. The lordship will immediately get it. The department says for 630 days, it has to be calculated 3 minutes. May I read for the lordship?
Yes.
Yes, sir. In case where interest is payable on the amount of input tax credit wrongly availed and utilized in accordance with subsection 3 of section 50, the interest shall be calculated on the amount of input tax credit wrongly availed and utilized for the period starting from the date of utilization of such wrongly availed input tax credit till the date of reversal of such credit or payment of tax.
Election notice. 17. Revenue entry is wrong. After how many years this IA gets filed?
Regarding not the leading the rebuttal evidence.
Huh? Sorry, who's speaking?
Issue pertaining to not leading the rebuttal evidence below.
No. But the argument stage you are asking for reopening, आपने बोला था इसलिए हमने notice
Petition is pertaining not just for leading the rebuttal evidence by the appellant side. Initially, my lord,
but only one question to you: what stage when the suit is filed in 2011, when other side also completed, assuming for a minute that the evidence was examined by the other side in 2018, you can't ask it to be reopened in 2025. That's the problem here.
My lord, on that day, my lord, it was dismissed on default because my lord, the lawyer did not appear, my lord. Thereafter, the restoration application was restored, my lord.
Very, very unreasonable. Thank you.
Lord, kindly see page 32 of my paper book. It was restored.
The suit is being concluded. You just open up for reopening the evidence. Thank you. To dismiss.
Lord, at page 32, Lord, restoration application was allowed, my lord. And thereafter, my lord, the Lord opportunity was granted for my lord leading the rebuttal evidence. Lord, kindly not just only one line,
not
not page
necessary.
30.
Thank you. Yes.
Page 30.
Item 18.
Judgment of the NCLAT is ignorance of the order made by a lordship court in the matter of K.H. Khan. K.H. Khan's order, which my lords made some time back, saying that exclude the properties which are not owned by the corporate debtor. Please have a look at the order made by lordship court. This is simply pending for lordship court, my lords, to examine whether under 81F property it has to be excluded. Please see the order of the honorable court and the petition pending for lordship court already.
On facts, not
This was, one second, please allow me to complete. This, my lords, kindly see the order of your lordship court on 31/1/25. Honorable court said in para 2, pending disposal, lordship will see the next page, my lords, on the top. The scheduled property shall not be dealt with in the CIRP in CP number so and so. Then the court made another order. Subsequently, after the plan got approved, the lordship said, escort the property and let the plan go ahead. Kindly see the order of the lordship court. This is pending for consideration before the honorable court today also.
Where is that?
The court made a detailed order. Lords, court said, kindly see, my lords, the last page, para 5.
Final order.
Yes, my lord, we make it clear that so far as scheduled property that is so is concerned, it will be subject to the final orders passed by us in civil appeals. Now, in my case, my lord, please consider facts are much better because here I have an arbitral award in my favor by 3 honorable judges of this honorable court saying this agreement is non-operative. This agreement is non-operative in 2022. 34 is confirmed. Now, my lord, collaboration agreement says land is owned by me admittedly. On the land, CD was to build up a construction. I will get 33%.
If it is
No, today, to difficulties in the CIRP, I moved an application to the NCLT. Despite K.H. Khan, NCLT rejects my application to exclude this land, at least saying unsold inventory should be kept apart. NCLT rejects this, my lord, and NCAT confirms it. And please see the NCAT order at para 9 and para 25. Complete contradiction. Roshi may have a look at para 9 first of the impure order. Because K.S. Khan said, my lord, honorable court said that under 18(1)(f.
Not a precedent, it's just some arrangement made there.
I agree, but when we consider, so the NCLAT will please consider.
Surprising how these two are connected.
I tell my lords why. Lord, please consider.
You missed out on something or.
But I mentioned why. NCLAT in K.H. Khan says that don't have to exclude the properties owned by the corporate debtor. Now, my lords, the matter comes to your lordship court. NCLT relies upon K.H. Khan to deny my rights.
But what has that got to do? This stands on its own footing.
No, but the facts are similar, my lords. Facts are similar, my lord, in the sense the properties owned by
the same people.
No, different people. But please consider the submission. Legal submission is, my lord, please consider. Legal submission is if today asset is not owned by the corporate debtor, it cannot form part of the corporate insolvency resolution process. That's the legal point. Under 18(1)(f, the IRP can take custody of only those assets.
I understand, but then this is a fact whether it is
Because please see, my lords, arbitral award.
What's the point in showing that?
Because the court. Can I say, my lord? Lordship, have a look at.
Where the admission?
Yes, kindly see, my lords, kindly see. Honorable court, may I look at, my lords, para 10.
The include order.
Para 9, my lords, consider, please consider.
Yes.
Para 9 also may consider. This is para 9 order of the RERA. Directions have been issued to both. Honorable court may have a look at para 9 of the impugn order. Have been issued to both. Honorable court now see para 46 of the court portion at page 10. This is the order of the RERA, which is relied upon the authority. The promoter may be restrained. It's an order made by RERA which operates today. Promoter may be restrained from selling the unsold inventory and would be bound by the arbitral award passed by the arbitral tribunal. Now, please have a look at para 10 now. The above order of the RERA authority clearly indicates that the authority has passed order to implement the collaboration agreement entered between the parties. RERA, I'm sorry. Where RERA has also noticed the interim order passed by the tribunal on 2/12 to maintain status quo. Under the orders of RERA, both the landowner and the CD were obliged to carry out and complete the construction. Collaboration agreement between the parties, etc. was 25 minutes. I'm sorry.
Yes, we have read the intro order.
But 25 laws should be considered to have a look at you. As noted above, at page 24.
Yes.
As noted above, present is a case where the prayer of the appellant to declare the development agreement terminated by the appellant was refused by the arbitral tribunal. This is factually incorrect. I show my lords the award of the honorable judges. Order of RERA.
The two submissions, completely different facts. 2010 development.
This has got nothing to do with this.
Just 4 or 5 facts will clear the entire air. 2010, landowner enters into an agreement with the developer.
Correct.
2018, he wants to terminate. The developer takes an injunction. Matters go before HERA, Haryana RERA. Haryana RERA says both the owner and the developer promoters, so far as the allottees are concerned, therefore both of you would remain liable. Arbitration starts, arbitration proceeds. The arbitral award specifically says, insofar as this arbitral tribunal is concerned, we are only dealing between developer and the landowner. The allottees are not before us. We take note of RERA's orders, which is protecting their interests. With the two of you, this may be inoperable. That's all. It says there and stops there, and it says in between the two of you. May I just say that, show your lordships at page 290. Then, the RERA proceedings are continuing. The appellate tribunal now correctly notes when he tried to terminate, there was an injunction that was granted. The arbitral tribunal notes that injunction restraining him from giving effect to cancellation continues to operate. Arbitral tribunal notes RERA orders are operating, protecting the interests of the home buyers. We cannot come and do anything there.
In a way, that process is going on, right?
Correct.
That will have
lastly, most important, and that's the reason for this matter to go, is this section 7 was initiated at the instance of home buyers. Some of them approached RERA, some of them approached under section 7. So, at the instance of the home buyers, where both of us, I'm sorry, when I represent, I say I am the RP representing the corporate debtor. Corporate debtor and the landowner, are both responsible to the home buyers. Home buyers section 7 comes to be admitted.
He's for the landowner.
He's for the landowner. Now, what he says is, I terminated prior to the CIRP. I went to arbitration. Arbitral tribunal held. No, arbitral tribunal did not hold. The difference with the other cases that Milan difference wants to refer to,
what's that portion of the award?
Yes, page 219. And you also ask for a further relief thereafter, 219 minutes. But may I start from 218 last second para? This is it
goes, if the property is available,
nothing remains.
No, that's not for you. But then this is what is the nature of this property?
I'll give the 3.4 acres of land. Admittedly. In Gurgaon.
But then on what basis will we
and his rights are protected. I'll show you lordships. At page 218, it first notes the RERA order tribunal. Page 218. From the bottom, my lord, your lordships may see in the last half of the page. This is the RERA order which is extracted, then the last two paragraphs. It is quite apparent from the view expressed by the authority and the direction given that the construction should be completed. It proceeded on the basis that the collaboration agreement between the parties and the supplementary agreement are still. In view of the directions given by the authority, application was filed by Ishan Singh before the tribunal on 22nd March. But if I may go to page 219 after the extracted portion. In view of the apparent conflict between the orders passed by the authority on 9 February and the order passed by this tribunal on 2nd December, this tribunal took the view that the conflict will have to be resolved by an appropriate forum. Accordingly, the tribunal did not entertain the application by Ishan Singh, left it open to take necessary steps. At 220, after the extracted portion, the tribunal is informed that the Punjab and Haryana High Court has since vacated the interim order at their instance and dismissed the writ petition. This is very important.
RP is here today?
RP, I am representing RP. But the next para is the most important. As far as this tribunal is concerned, The agreements cannot be operated and no directions can be given by the tribunal for specific performance of the agreements. That being so, the agreements are paper agreements along with the powers of attorney and they have no real meaning. But the penultimate paragraph. No, please. My learned friend may allow me to read the order in its entirety. The penultimate paragraph on the same page, 220. The third set of reliefs prayed for by Ishan Singh in part 1 of the counterclaim for mandatory injunction, giving the project land and indeed the project to him, and for the transfer of the project and all related documents, licenses in his favor. This relief cannot be granted to Singh for a variety of reasons. Firstly, proceedings instituted by some allottees are pending before RERA authorities, Punjab Haryana High Court, and any substantive order might adversely affect their interests, and that cannot be done without hearing them. Secondly, since the revised building plans are under challenge. Next page, 221. First sentence. Since this is already covered by the collaboration agreement between the parties, no further direction is required to be given in this regard except to clarify Ishan Singh is and will remain indemnified by Space Travers in respect of any liability arising out of or in relation to the collaboration agreement. So today, my lord, it refused to give the land back to him, the arbitral tribunal. It said that insofar as we both are that entity and they are concerned, it is inoperable, but they will stand indemnified. Now, Section 7 is filed by the allottees. I mean, not the tribunal.
What happened to the award there?
Pending in 34.
No, we won.
We won the
37 is pending.
Yes. Even if the award, even if the award becomes final,
what is happening yesterday also we were doing exactly the same.
Also, if the award becomes
multiple forums and multiple
even if the award becomes final, your lordship may only take that basis. It will still mean the allottees are not there. Allottees are before NCLT. Allottees may not initiated. They are entitled to initiate.
We just issue notice.
To the extent of his interest,
May I just say one thing in the civil appeal, Milods, we keep it for final disposal, we'll finish it off, Milods, in a short time.
We'll see. Issue notice. Who else is there, Mr. Niranjan, apart from you, contesting parties?
It's at a plan approval stage only. It's moving forward.
We are not granting any information.
Plan approval also, I'm told one of the plan applications are filed by his brother.
Can I?
17259.
Before us?
Yes. It's an IA for intervention and seek to withdraw on behalf of one of the interveners.
You want to withdraw the IA? Withdraw what?
Withdraw the intervention application to one of the applicants. That's all. That's
we will allow it.
Can I only request
that we will allow it. Give us the detailed issue notice. For the present, we are not going to pass any information.
One small request, if command consideration, not the land part, only one small request, command consideration, your lordship court. COC takes note of the fact today there are 190 unsold units. That can be protected. That's the only request.
Give a short date.
Short date.
Issue notice. Who are the other students?
I had filed 2 IAs, one for 2 people, one for 4 people.
We will not pass any orders on that. We are not rejecting anything.
My learned senior is withdrawing for applicant number 1 in one of the IAs. For the rest 5 applicants, I am there only.
All right.
Yes. So that application.
That we will allow. That we will allow. We just issue notice for the present. We will examine.
May I request a short date? We'll finish this matter in a very short time.
Milord, I appear for the suspended directors. We were heard in the matter, but we are not made a party. The impugned order records our submissions, but they have not made us a party.
So great.
We can't reopen it again.
Obliged.
On the next, yes. Next time we'll see. Item?
Wait, please, my lords. In item 19, coming after notice, I seek to file some documents, my lords. It's a case of reversal in a specific performance case, my lords.
Could my lords post this matter on NMD? Otherwise, counter has already been filed.
Next.
There's 23 SLPs that come after notice, and the pleadings are complete. The state has filed its reply in 2 of the appeals, but the question of law is the same. My lords may set it down for hearing. It's a pure question of law.
State is here.
Yes, my lord.
Have you examined?
They filed a reply and they agree with our contention.
May I make one submission in my case?
Regularization.
The question of law is whether
your regularization application.
they are all now abiding by the High Court judgment. My lords have granted us status quo, and if my lords decide that there is a power, it will have to be remanded back.
May I just make one submission in my case?
In fact, in one case, it's been allowed.
Just 1 minute. Just one submission in my case, which is 20.1. I appear for the original complainant. In my case, there is no question of regularization because the purchase was under 18C of the Goa Agricultural Tenancy Act, which anyway there is no conversion permitted. So there is no question of construction and regularization.
These are questions the authority will decide by.
The authority has decided against them, and it is being tagged. Your lordships may detag my matter.
No.
We convinced us somehow that day.
No.
With the greatest respect,
My-
my
We are wondering why we are.
with the greatest respect, all three judgments, please, very much available under two provisions, and the state also says so.
Mine is different as my submission, Your Lordship.
My lord, I am for.
My lords may keep it on any Tuesday at 2 o'clock, my lords. The common question of law will have to be decided. Prepare the 2-page.
Two cases, Rashmi?
No, I don't.
My lords, so there are
those
three.
cases.
May I just point?
Only
The three
Stand
cases.
on the same footing also?
The first case is a reconstruction of a not at all, my lord. The first case is a reconstruction of a temple where the High Court says there is no power of regularization, and another is of a toilet. So
Can mine be detagged?
Put us some, put us, no.
I made a 2-page note, my lord.
Doesn't matter, you do it at that time. Show us the pictures of how it is
I do.
next time.
And I filed a compilation of all the acts. In Lordship will have.
Yes, we can
Put some pictures of that.
I-
We filed a very short affidavit saying that the power to regularize is there. Whether we will exercise it in this case or not, that once your lordships clarify.
That my lord.
And for
For the
the
government, state.
We must appear in
My case also specific.
In my submission, my lord should decide the question of law and leave it to the authorities to decide, because they were all at different stages.
We'll see holistically.
Obliged.
Obliged.
Let's try the double. That of matters. Almost all lordship are being led by the double agencies on legs in court
We'll
one.
have it on some other day. Next.
My lord, what do you want?
One is concerned, madam.
Matters that notice has been issued, my lord, as far as the that substitution is concerned, my lord. Lords have been issued notice on those matters.
Have it on some other day. Next.
Much obliged. Business. Item 22 comes after notice, Mullahs. Counter has been filed, Mullahs. Mullahs, the point is, Mullahs, I was the builder, Mullahs. I was supposed to hand over the flat, Mullahs. Now, Mullahs, there was delay from the buyer, Mullahs. Yes, Mullahs. No, Mullahs, a very short point. Mullahs, what has happened is,
SCDRC, High Court.
Yes, my lord.
High Court's compensation and possession, Nachket.
No, Mullahs. There was an alternate prayer in the consumer complaint. Would my lords kindly see page 159? Kindly see the prayer at 159 in the consumer complaint.
No, Mr. Jurisdiction of the High Court under Article 226 is discretionary in nature.
Yes,
So,
Mullahs.
It cannot be invoked as a matter of right.
No, that is right, Mullahs.
High Court has recorded a reason that taking into account your unfair conduct.
Because there is no, I'll satisfy on that because there is none in
Yes,
terms of
yes.
my conduct. What has happened is, flat.
Of the amount, only 1.5 lakhs was required to be paid. You
Yes,
cancel the allotment
That's right.
to a third person.
Yes, Mullahs. Now, Mullahs, that cancellation happens. He doesn't challenge that cancellation. Because the complaint is filed. Now, Mullahs, the alternate prayer was very short point. Mullahs. Alternate prayer was in the complaint, Mullahs. His alternate prayer is that the opponent, if the opponent, that is me, is not in a position to hand over the possession of the flat, he be directed to pay the current market value of the said flat. Now, Mullahs, therefore, the current market value with interest, Mullahs, is what we were offering. Mullahs, before the National Commission also we've offered, Mullahs, we are ready to pay the current market price on the date of the application, Mullahs, or even at the date of the judgment, Mullahs. It cannot be at the current price, Mullahs.
Thank you, Nachket.
So this is the short point that whether current price should be considered or, Mullahs, will it be on the date of the application, Mullahs.
I'm grateful.
Thank you. Dismiss. Next.
All right.
Second appeal remand for remand दिया है फिर है second appeal. the trial court to decide it quickly instead of all the whole process of we restore it in the first appeal.
May I answer,
Again, you will come to the Supreme Court.
May I answer, my lord, in 1 minute?
In your favor, we are saying.
I agree, my lord. One minute. My lord, the suit can be amended, no difficulty. But the finding of a first appellate court that as far as the sale deed is concerned, my lord, kindly have page 87. Even the sale deed does not have the boundaries. How can they rectify the sale deed?
No, all that the court said that let the trial court
The register sale deed from where they are having a title, they are claiming a title. It has been seriously doubted. What I am trying to say after 35 years, my lord, is directing to remand back and they can amend the plain. So, my lord, the sale deed in 64.
What do we do? How do we? Can we?
My lord, kindly have page 86 for a moment. I will just leave it then after, my lord.
Interfere, we request the trial court to take up and dispose of the suit as expeditiously as possible, preferably within a period of 6 months from today. Both the parties have agreed that they will not take any adjournment in the matter and shall cooperate with the disposal of the suit.
My lord, may that indicate that the fine, as far as
the 6 months, that will help you.
It's in his favor, my lord. Our High Court order is actually in his favor. I don't know.
In 24, my lord had given me time to file rejoinder. My apologies, my lord. I'm praying for 2 weeks more.
Next.
2 weeks for rejoinder.
There's just one humble prayer, my lord. Some date may be fixed.
We will.
And my lords, in the interrogative, there's just one. Yes.
25 letter.
My lords,
Item 25.
With the name also.
There's a letter there.
No, interim order is complied with, stay may has to be extended, not stay.
Interim order to extend.
Great, Lord.
Next.
Wait, please, Lord. I appear for the response.
We'll examine this. 2017 letter 16.
Yes. 1725 and the law, my lord, because what has happened is it's not as if the impugned order says that he's not guilty.
Even on facts, they have. I court has said even on facts they said it's no contempt.
And my lords have said
They
that
having said that the law is not.
My lord, the law today, your lordship's judgments.
Other than contempt, what is your contention?
My lords, our principal contention is only the fact that there is a stay order in my favor. He violates it admittedly.
They have explained. High Court has explained that, right?
No, my lord, High Court is. May I with respect, my lords, explain it by own way.
Mr. Paul, what we are saying is in a contempt claims, you don't get into the nitty-gritties and examine. There will be so blatant deliberate disobedience.
My lords, I'll just explain. My lords, admittedly, it is blatant. They have taken and mortgaged after a prohibition order. The impugned order doesn't get into it. The impugned order only.
Order says that restrains him not to create any third party right.
The arbitral tribunal directs him not to create any encumbrance of third party rights. After that, admittedly, loans are taken and mortgage deeds are executed. When I file a contempt, the impugned order says that in the light of the fact that you have, in one case, my lords, mistakenly, we did not make individuals the parties, in the second we did. He said you haven't. In the second, the individuals will make a...
What happened in the meanwhile about arbitration?
So, my lord,
in the arbitration,
the arbitration is going on, and against the interim order, he's filed an appeal where there is no stay of the stay granted in my favor. The impugned order turns around and says in this matter that because of the judgment of the High Court in one matter, that a contempt in an arbitral tribunal's order cannot lie is contrary to the Supreme Court judgment in that very matter.
That's correct.
That in view of 17 and 25, the only two grounds, I'm non-suited to say that we don't have the jurisdiction. The law of Bombay High Court is correct as laid down, which is overturned by the Supreme Court. The second point said is, you have not informed in the contempt petition or explained what is the role of the contemners. Now, my lords, they are the directors of the society. They have signed the mortgage deed, the 73(1) AB of the Maharashtra Cooperative Societies Act.
What do you say about their defense taken in the counter here?
Yes.
That this is all a bona fide transaction taken with the permission of the Superintendent Commissioner and was done in a transparent manner.
That
to run
resident
the
commissioner,
sugar factory.
that permission itself says subject to the order, stay order. That they don't point out to your lodges, that very order of the commissioner, charity commissioner and the arbitrator say, the commissioner in turn says that it is subject to the arbitral tribunal's order. Where is the stay operating? Now, my
They refer to the arbitral tribunal's interim order.
Yes.
Dated 2924.
These my lords.
Yes.
Now let's kindly have page 178.
What have they done according to you?
My lords, please just have 178, 179.
They said that don't create third party rights and they have created third party rights.
My lords, they have taken in excess of 200 crores. They've taken loans and mortgaged the same sugar factory and its appurtenant lands for the same loan. And it's not a loan only for the factory, it's a loan for distilleries also that they have taken in the matter, which I'll show to your lordship. They came here and tried to project a picture of farmers with supper.
There are 2-3 things. First, the very arbitrator gives permission to us.
No, you have to
to
answer
create-
the 2924 order.
Yes, now there
Have
are
you violated it or not, as simple as that.
3 things. Lord, please have a permission granted. We go before the arbitrator, make an application, he approves it. He says therefore there is no willful disobedience.
No.
Now the second
2924 says that don't create third party interest. Have you
Right.
created it or not?
Now what happens is we have
Have you
obtained
created
loan.
it? It's as simple as
We
that.
have obtained loan by mortgaging the property.
So you mortgaged. So we violated it.
Yes, but no, we haven't. Before that, we move the arbitrator, make an application. He approves it. He grants us permission.
When is that order? When is that?
That page number.
Give us the date of that.
The counter.
Give us the date.
Yes,
Give us the date of that approval.
That is page number. What is the date?
Give the date.
What is the date? 23rd of January 2025. Page 69, if your lordship see. And another, there are 2 letters.
That ends there if you post that order.
Yes, page 69 of the counter. Page 69 of the counter, my lord. And I wish to show, my lord, how
was that order? That's an answer to complete.
Yes, page 69
of the counter affidavit.
Of the counter affidavit filed by us.
Where is the counter? Reply page.
Counter by respondent number 1, page 69.
Paper book there. 69.
It's the same.
Yes, show us that.
Page 69.
No, 69 is Sugar Sagar Maharashtra State Complex.
Yes, that's sugar commissioner and the arbitrator is the same person.
Okay, where is that? Come straight to the relevant portion.
Yes. If your lordship sees, paragraph 4.
Yes.
Similarly, in connection with which the application for attachment before judgment filed by aforesaid PD so and so before the sugar commissioner, while his office reference number so and so, therefore subject to the interim order, in order to give loan by this bank to Sri Ganesh Sugar Factory, there is no objection hereby. Now, my lord, please see the second letter also.
What is this got to do?
Now, this arbitrator, my lord, he is the sugar commissioner. He moved an application saying that we are the sugar factory, and now we are the sugar factory. We are short of funds. We have. Yep, and
This is the second letter. Same as
yes, permitted to, my lord, to borrow loan.
Similarly, in connection with
Page
the
75, your lord, this is the second letter.
filed with this one. So
This is the NOC given by the arbitrator. And please see 75 also. What happens?
The order is very clear. It says that
No, but what happens is, my lord, I'll tell you, lord. What happens is, my lord, there are 2-3 aspects which I wish to place before lord. One, my lord, we move the arbitrator and seek permission because we wanted to borrow loan because the sugar factory will become non-extinct. That's the reason, my lord. One. Now he agrees. He says yes. We grant you permission. We grant you NOC. I grant you NOC. That's what he says. On
How do you object to interim order?
Sorry,
Subject to the interim order.
Yes. Though he says so, but
No, but tell us, how do you answer that subject to interim order?
what he says is subject to the interim order, right? He says so.
The interim order you can't violate.
Oh, but please see 75 also. 3 letters he issued.
Therefore,
Please see
therefore
75
one thing is clear, this order doesn't help you.
Now there are 3. Now therefore, whether there is a
But
willful default or not.
What is the next order?
Now page 75.
Does he bail you out?
You're watching me see 82 first. 82. Paragraph 4.
If you are not satisfied, then we're going to post.
Please see page 84, 83, 82 minutes.
Either believe that
I will show
it has occurred, or we are not going to spare you if it is a.
No, of course.
Just an argument.
I will have to, and this arbitration.
Tell us how does this 84 bail you out?
Page 82 minutes. You're watching me see the bottom. What is it? Of course, it says the subject to the interim order. What is this? Yes. Paragraph 4. Further subject to the interim order referred to in the reference number 1 in the arbitration claim and according to the terms and conditions mentioned in the reference number 2, this office has no objection to the execution of the mortgage deed for providing the working capital loan facility of rupees so and so sanctioned by Ahmednagar District Central Cooperative Bank to Ganesh Sahakari Sakhar Karkhana. Milord, I'll tell your lordship, just give me a minute's time.
You don't take us here and there.
Yeah.
The 2 letters that you are relying on, those letters itself says that whatever we grant you will be subject to the interim order.
Yes, of
it
course.
Doesn't need any vocabulary higher than this,
may I
nor
say,
any interpretation than this.
Now let me say something. Now there are 3 things which I wish to tell you about. This is one. Therefore, there is no willful default. That's my first submission.
Clearly willful default.
Now second. Now how these proceedings arise. Now, Milord, there was a lease agreement of 2040 between. Just give me a minute's time. Okay. How it arises? Just give me a minute's time. 2040.
Anyway, you ask your fellow to be present here.
Now just give me a minute's time. 2040. There's a lease agreement between them and me. We had leased this property. Just give me.
Why do you need all these orders but chart? Where all permissions are given subject to all. Don't do this with me back and forth. I hate that. Right? It's subject to internet. The order itself says.
Permit me to say something.
So the content petition, you proceed further.
Just give me 1 minute.
That's the way it should be done.
Just give me 1 minute.
To assume that he doesn't have content.
Just give me 1 minute. 1 minute. There are 2 things which I wish to place before your lordship. This arbitration proceeding, in fact, Milord, is of 3 years old. Therefore, Milord, the period has also gone. Mandatory period has also gone. Milord, they have sought adjournment on every occasion. Milord, I have filed that. Milord, the Roznama. 1, 2, Milord. Second, how does it arise from? 2000. Just give me a minute's time. 2014, there is a lease agreement between them and me. They want to see, Milord, that this sugar factory does not function. Now, just give me a minute's time. The reason being, Milord, there is something important which I wish to tell you. 2014, there is a lease agreement. I will not take more than a minute's time. 2014, there is a lease agreement. I have to, Milord, they lease the sugar factory.
That's what we will do is, that High Court rejecting the content petition was not correct.
Very well.
It has not examined the matter. We will set it aside in view of the judgment of the Supreme Court. We will say you have raised the defense on the basis of these 2 letters. It is for the High Court to examine.
Very well. Let it be decided immediately. Very well.
Then your lordships are also pleased to pass a stay here also because they were continuing. That must continue till that is decided. Your lordships pass a stay in this.
Yes. Milord, may I say then, Milord, let this contempt petition be decided in a week's time because, Milord, these are...
Okay,
yes.
Especially petition is against the judgment and order, be granted for judgment and order passed by the High Court, dismissing the contempt petition on the ground that it is not maintainable. We'll stop. For the present purpose, we did not delve deep into the facts except to say that the maintainability of the contempt petition is no more res integra in view of the judgment of this court in so and so. What is the citation? 2017.
Yes. सारी चीज राइट के अंदर घूम घूम के नहीं देखी जा सकती.
Yes.
Mr. Sudhanshu.
Yes,
Shall we just keep it, we not say anything more?
Let all the questions be kept open, let the contempt petition be, because we have a question about maintainability also, another question.
Of Mr. Neeraj Kishan Kaul, senior counsel, that despite the clear and categorical order of the arbitral tribunal dated 2/9/2024, the respondents have entered into mortgages. Mr. Sudhanshu Chaudhary seeks to support it on the base letters dated so and so at page 72 and 82. We are not inclined to examine the merits of the matter. In view of the fact, full stop, in view of the fact that we are restoring the contempt petition, it is open for both the parties to make their respective submissions and for the High Court to consider and dispose it of on its own merits. What else you wanted?
No, within a period of 1 week.
The High Court shall in a week's time. Anything more?
The interim orders to continue your
Interim
lordship?
orders to continue.
Grateful.
Only one submission. So far as the interim order is concerned, that is 2nd of September 2024.
Pending
passed by
disposal of the contempt petition, the interim order
for the bank.
passed by us shall continue till the final orders are passed.
Great.
My submission, I am for the bank. My lord, the sugar industry runs only on the basis of finance. You have to play. I am not on that. 2/9/2024 order passed by the arbitrator. Kindly see para 24 and their amendment in the arbitration petition at para number 25. My lord, it is not clear. It is not clear that the properties are not mentioned. My lord, properties are not mentioned. We have not been prohibited from executing the mortgage deed, my lord. Absolutely, my lord.
What we are saying, in any event, you do what you want.
Grateful. Extremely.
Because I am not party, I may be excluded.
That's right, that's right.
As far as bank is concerned.
That way, we have kept it open-ended for both of you. Next.
There is one more request. There is one more request, Milord. There is a miscellaneous civil appeal against that interim order. Milord, they are going on seeking time. Milord, for 3 years they did not allow it to go ahead. Milord, if your lordship sees the Roznama, let that is listed on 4. Even let that also be decided, Milord, immediately. Milord, because they are not allowing it to
That's
happen.
not before us.
Grateful.
Next.
Item 27, my lords, and appearing for the petitioner. My lord said it should notice, my lord, the other side is yet to enter appearance in the matter.
After services. 28.
My lords, the interim orders to continue in 27, my lords.
Yes.
Yes, obliged, my lords. Great.
Serious objection to the adjournment request.
Item 28.
I have a serious objection to the adjournment request.
How many times?
No, not times. See the prayer.
The union has to take a stand on their.
I have not filed counter. So the respondent says adjourn the matter because they have a stay in their favor. Just have a look at that letter.
What is this?
So you're not done. Lordship may hear it. I don't.
My friend we chose not to file a reply.
Doesn't matter.
Allegations against him.
Letters are this. 1 minute.
Just see the letter for adjournment for
Yes. Particulars thereof are given below. Why?
Just have a look at that letter. Lordships have that letter.
Where is the reasoning?
Below, sir. Rest whether
counter affidavit
pleadings
not
are
filed.
not complete. No counter has been filed by respondent still date. Serial number 4.
Counter affidavit not filed. Pleadings not complete.
Your lordship said, I don't know why my friend is objecting. If he wishes not to file a counter, that's fine.
But how can you ask for adjournment?
The point is this, Milord. Your lordship said,
Can you ask for adjournment because
Milord, we ought not to have, Milord. But Milord, the union stand is important because your lordships are interpreting Rule 39 of the Company Incorporation
Okay,
Rule.
next week.
Yes.
Yes, Milord.
But your lordship direct R3 to R4 are considering their rules. That's why we
People have the choices of filing or not filing. What can we do? We can't issue contempt.
Next Friday, Milord. Next Friday.
Next Friday, not
Next Friday, Monday week. Monday. Great batch.
Manoj, I'm appearing. Sorry, I've just been unmuted. We want to file a counter, but because there was a letter, Manoj, we'll file it.
Do that.
Yes, Manoj. Kindly give us 2 weeks, Manoj.
Okay.
I'm grateful, Manoj.
Obliged.
Grateful.
Then it will come after that, right?
May I please, Your Lordships? Your Lordships, as per the last order, the child has seen and met the grandmother. However, there are certain issues. So, in fact, I had put a suggestion to my learned friend. Now, what has happened is we have already given them an application for settling all the issues. However, we have not received any reply.
What do we do?
Now, only for those issues, Your Lordships, if a very senior mediator could be
What is
appointed.
pending here?
Just custody.
Custody is not pending here, Your Lordships. Please.
This arises out of the order passed by the High Court, right? What was the direction there?
No, Milas, this was a transfer.
This was a transfer.
Transfer petition, right?
Yes.
So what is to be done finally? So
Milas,
far-
we just have.
Don't convert this into a custody petition.
No, Milas.
So we'll take up the transfer petition and then see what can be done. Now that interim arrangement which you wanted, you are seeking transfer of the DV case, right?
Yes, please.
From Pune to Amritsar.
Yes, Milas.
So
In fact, the petitioner has not even once appeared before Your Lordships here.
No, he is.
She can appear to
He has appeared.
My suggestion.
He's in UK, Milas.
No, the petitioner is the mother-in-law.
One minute. You are, where do you stay now?
In you, Milas, I am
You are the mother-in-law.
I am the mother-in-law, Milas. I stay in Amritsar, near Taran.
Why the DV case from Pune? Why should it be transferred here?
Milas, actually, it is. I am 76 years old, Milas, and it is 1800 kilometers from my.
What about Priyanka? Where does she live?
Pune.
She is in Pune.
Where will we transfer that? How will we transfer that?
Sorry.
He's with the
How
child.
will the DV case filed by her
Milas,
be transferred to Amritsar?
Milas, the only thing is that I am 76 years old right now, and it is 1800 kilometers from my place. I have serious ailments. I cannot travel.
Lordship, she just traveled to Pune right now.
So appear to VC.
Milas, we will do that. Milas, before that, just for 1 second, Milas, we have this order dated 20th of August 25
The
of
problem
this
was
article.
when we took up that matter, it's about the visitation issue which came up for consideration.
Yes, please.
Which is
We thought we will help both of you
Yes, please.
to enable the mother and the father to take the child
Yes,
to
please.
the grandparents. To that extent, it's worked it out. But transfer of a DV case, which is filed in which year?
23 minutes.
Then how will it be DV? How will it be transferred? It can't be. We will give you VC facilities while we are not inclined to interfere with the transfer petition. We will not inclined transfer petition. We are not inclined to interfere with the transfer petition. TP is hereby dismissed. However, if VC facility is available at Pune,
Your Lordship, I have instructions here. We are not claiming any relief in the DV against the mother-in-law. So, in fact, we are ready to even delete her from the proceedings there.
Very well, Milas. Very well.
Just the mother-in-law. That's
Very
what
well.
my
Very
instruction.
well, Milas.
Learned Counsel, Learned Counsel for the respondent on instruction submits that her client is willing not to proceed against the petitioner, MS Dr. Neena Nair, in the DV case pending before so and so court pusher. In view of her statement, the trial court in so and so shall strike off the name of MS Neena Nair,
Dr. Neena
Nair, from the array of parties and proceed against the other accused in the case.
Please, Milas, I just have one request. If Milas may allow me just. Milas, actually, during the all mediation settlements going on before this honorable court, Milas, the husband actually has paid 45 lakhs towards the entire alimony, Milas. 30 lakhs towards the FD of the child and 50 lakhs to the wife, please.
You are for the mother.
Milas, actually,
That's amended.
I am the mother. I am for the mother.
Exactly.
Milas, then
Why are you arguing that you are the mother-in-law?
Mother-in-law,
You are right.
Milas, the respondent number 2 is the performer party only. Milas,
Call the next case. Thank you. Next
Please
case.
give that.
Oblige.
Item number 30, I appear for the petitioner in this matter, Milods.
Is there any settlement? The notice was issued by another bench. It was confined only.
Milods, we have instructions to withdraw the petition, Milods. The parties have amicably settled the dispute, Milods.
All right, we'll do that.
Yes, Milods. And the subject matter maintenance petition has already been withdrawn, Milods. So this matter is already infectious, Milods. Milods may record.
Next.
Much obliged, Milods.
Please, Your Lordship. This was issued on 10th of March. Service is also completed on 20.
Anybody?
Nobody has entered appearance.
DV case is pending.
Hello?
Service is complete.
Well, it was on 24th of March only. After that, the matter was got listed also on 6th of
We'll
May.
wait for some time.
Well, there are matters which are getting listed there also. It is 8 hours journey for this lady to travel.
Nobody is appearing that side. March now. March.
On 24th March, it was completion. Very.
Item 32.
Your Lordship, I beg to appear on behalf of the petitioner.
Daughter is with the mother.
Milord, in this matter, Milord, trial is at fag and it's a 2021 petition, Milord. So, petitioner's evidence has already
What
been
do you say
about that
Well, it's not, as per their own statement, 1 out of the 3 witnesses only have been examined, and even the first one is not been complete.
That respondents.
He's saying that the trial is almost in the concluding state.
Well, but that's not what they say in their counter affidavit. They say they're still a witness.
You take instruction.
Milord, let
You
the
give
parties.
the last few proceedings or something like that. File documents.
Milord, I'll do that. Milord, let the parties be sent to the mediation, Milord, because it's a matter.
Well, I have.
Refer to mediation. Next.
Much of
33. Yes, issue is to be heard, no?
No, but there is an issue today. It's a very short issue, but your Lordship should know that. Well, it's the issue in the main matter, which I'm saying only to let your Lordship know what it is, and then I will tell your Lordship what the problem today is. Well, it's an SLP, a civil appeal on 2 issues. Recomputation of rate of carrying cost for a period 0708 to 1230, and well, it's additional O&M expenses which are disallowed. Now, that's the main issue. According to us, that issue has been decided against us directly contrary to 4 things for us. Supreme Court order of 15/12/22, and well, I'm not arguing the main matter. On the main matter, no, today is a very narrow issue. I'll tell you in a minute.
May I,
Mr. Venugopal, allow me, please, sir. I'm on my. The main issue is that this order, impugned order, violates a Supreme Court order of 15/12/22 and 2 other orders of NDPL which have been affirmed by the Supreme Court. Right, Police? That's the main. Now, today, the issue is much narrower, which I'm only asking was perhaps for Mr. Venugopal's benevolence, part of Lordship's discretion. On the last occasion when the matter came was 22 May 26. Mr. Venugopal fairly said that he will file his reply to my stay application and that till then he will take no action.
Orders, even if passed.
Till then he will take no action. Now,
statement
he has
we have
filed,
made.
well, unfortunately, his client has filed after a delay of 40 days and we have received it yesterday, 29th. The government has filed something which Lordship doesn't have, which we have not received. We have received on 30th. All I am saying is, for 1 week, please extend that assurance because there is a separate matter of the same DRC where they made a commitment to Aptel that we will not stay our hands. And it will reopen all the past years.
We will have it after now. We don't have time. We will have it after 2-3 weeks.
But here there is a catch. My learned friend must make the statement must be one second. Your Lordship, that should be formalized. Otherwise, they are going in the Aptel. They are directly proceeding in the Aptel. That's the problem.
With respect, my lords, what my friend says.
What we will do is instead of we don't
1 week only.
We'll just
2 weeks.
Next week we have heavy matters.
Following week.
2 weeks we'll just continue.
I must tell my lords what our difficulty is. They, my lords, when the matter came up in Aptel, never told Aptel that there is any urgency and allowed Aptel to pass an order saying that the true-up order must come today. I hope my lords I'm clear. The true-up order where I had made the statement and I'm, my lords, not disputing anything about making the statement. I'm saying that true-up order, they allowed the Aptel to insist.
Understand?
Doesn't matter now.
Our difficulty.
Okay, we will do it one thing. Okay, have it next week.
We have to file 2 rejoinders.
So I'm.
ये Tuesday नहीं, आगे वाला Tuesday.
My lords, may I just say one thing, my lords? This is only a true-up order. True-up means, I'll explain why I'm saying that.
Can we do one thing?
Well, why are we arguing this?
No, I'm
filing
only
a rejoinder.
We do one thing.
Having it 10 days later.
We are just having it after weeks time. We will dispose of, we'll take up and we might even not entertain
it's a short
in
point.
a week's time. Put it up next
But
week.
I
Tuesday.
just wanted to explain one thing, Manoj. if we pass the true-up order, no effect happens. It has to be only imputed to the tariff which comes after 2 or 3 months. So all that I'm saying,
5 years. What is
all that I'm saying,
5 years?
All that we are saying, we'll take it up next week.
Okay.
In the meanwhile, you just, in a week's time.
Mr. Venugopal is not resigning from his statement very fairly.
No,
He's saying now that 10 days, why should he pass throw-up order? Why should he pass a throw-up order?
My instruction, my lord,
Why should he pass a throw-up order in
My
1 week?
my instruction is not to continue the statement, balance, because the reply is
After filing the reply yesterday.
We are asking that no
After
state
filing the
is
reply
granted.
yesterday.
And balance, the Delhi government, Mr. Tushar Mehta was to appear. He has some very strong reservations,
We'll
balance.
put it up next week, Mr. Venugopal.
Yes.
Listen, 1 week they can't continue this.
Next week, next Tuesday, laga do, not this Tuesday, next Tuesday. The party shall maintain status quo till the next date.
Obliged, that's all.
Only till the next date of hearing.
Yes.
Only.
And we'll file rejoinders.
Only till the
We'll file the rejoinders to both.
Do it, we will dispose of the earlier.
Grateful, balance.
For final hearing on 7th,
No, 1 minute.
I want to file a reply
11th
to
is
this
what my lord is
argument.
given. Just
File my.
to be clear, my lord is given 11th.
Yes, sir. I want to file a reply to this IE. Which has been filed, this is coming for file. Next one, 34.
I have
34.
I must tell my lords. The order which he seeks a stay of, he wants a partial stay of it. While we had, my lords, filed the
I'll be arguing till 11th.
wanted, no, 1 minute. I allow you to go on. I wanted a full stay of the whole order, which was declined. Now, my lords, my difficulty is
Can we
this.
just,
11th.
I just want to finish. So, my lords, the entire basis of what he wants a stay of is that the 2011 regulations came in. That's
the merits. Monday.
Regulations were challenged before Delhi High Court and upheld. That came up before, my lords. Your lordships issued leave, granted leave, no stay. So, my lords, their entire case is 2011 regulations, which they did not get a stay, ought not to be applied. So, my lords, I'm only saying this. Allow us to pass the swap order. It cannot have any impact today because the impact comes when the tariff order
It is not a fair argument when he files 40 days late, agrees to continue the statement and then says he'll pass a true-up order. It's a very unfair statement. One instruction.
Very well.
I'll file a reply.
Item 34.
And this is on 7th, Malas. It's
Which item is this?
34.
1 second.
It's coming on
I am on 34, Mr. Pawar. Just 2 minutes. My IA is unacceptable and urgent, and it cannot lead to an object. Just note this, fellows. My IA is 189456. It says that iron ore is going oxidized, bad in the monsoons, and going to destruction. In a nutshell, paras are paras 9 to 13. Now, in the meanwhile, let me sell it. If your lordship has any doubt or my lord has doubt, put it in the account.
Two stay orders. The one is this honorable court has granted, which he want to vacate. One is the independent in some NCLT proceedings on page, which we are not even party.
We'll hear you.
Allow me
Yes,
to
hearing on 7th, Malas.
No, now itself.
Yes, Malas,
That's right. That's right. Allow me to just explain what I'm saying. I am today saying in IA 1894 that if I sell go bad in some time in the monsoon, I will put the money in an escrow account.
Yeah,
That's all I'm saying.
Agency, you can't spoil the.
What the issue is,
Just turn to my IA. Just turn to my IA for 2 minutes.
This is
IA.
Wait for a minute.
Yes, just turn to para 9 of that IA. I'll take 2 minutes only. I have only 2 prayers. One is unacceptable. The second one I'll come to in a minute. Just come to para 9. Does my lord have it? I am saying something which is where lordship's escrow account. I have no problem. Just come to para 10. It is submitted as the freezing of the business operations. Now come straight to para 12. 12. I'm shortening it. 12 is the para my lord is looking for. 12 page 7.
Been served. Has notice gone on the IA?
no, Malas. That's what it is.
Vacation.
Full of the statements which have been made are completely false. I want to file a reply.
Just see
Don't
12.
file a reply, take instructions on this.
I'll take it, keep it.
Take instructions on this, we'll take it up on Monday.
Very well, Malas. I'll take it.
Monday.
Very well. I can't say anything on Monday.
Monday.
And the second request prayer was on Monday, not today. That second prayer is his whole case is based on an agreement. I am saying it's fault. I say just send it to a forensic. No, that's all. Without prejudice.
Take instruction. But in a suit pending, my learned friend. I hold on.
A person who says don't send it to forensic has something to hide.
So
has something to hide.
Say the suit should not go on. So say relegate it from here. I'll hold on for 10 months.
Go on, send it to forensic nevertheless.
May it please your lordship. My lords, I have filed an application for extension of time, my lord. On 26/5/2026, this honorable court was pleased to issue notices subject to deposit of rupees 3 crores in 6 weeks. My lord, I have prepared a DD of rupees 1 crore, which is annexure A to my application. My lord, for another
fixed on the 17th of August. Let them deposit it before. They want to deposit all the way until October. Then and I'll tell you what.
We will vacate the plea if you don't deposit by the next date of hearing. We'll grant.
Lord, I will clarify, my lord. My lord, I have
last
business.
and final. Please don't take things for granted. This is the last and final chance we are giving. You just deposited by
17th.
What
the
is
matter
it?
is fixed on the 17th of August.
17th of August.
That's right.
Before us, huh?
My lord,
what
my
time
lord,
do you
I am
want,
asking for 31st August for 1 crore more and 1st October for 1 crore more, my lord. And
deposit by the end
is-
of August, or else you will vacate.
My lord, I will say something, my lord. This amount was to be
order
invested in
passed.
FDR. I will deposit the interest of FDR also, my lord. So no prejudice will be caused to them, my lord. This amount was to be invested in FDR. I will deposit 1 crore and another 1 crore along with interest which the FDR would have given, my lord.
Lordship's orders can't be taken for granted like this, that we'll get one order, then we'll.
Okay.
No, let them deposit the whole thing, Manoj. I have no doubt.
Okay. How much are you going to deposit the whole thing by the end of September then?
My lords, I will do that.
But the only thing is that it then defers the entire hearing of this matter, and they've
No,
got.
we'll hear you. Hearing has got nothing to do with this. In continuation of our order dated so and so, the petitioner is permitted to deposit the entirety of the balance by 30th of September 2026, failing which the interim orders which shall stand vacated without reference to the court.
No, then along with interest, because my learned friend said he deposited with
The matter is being heard. Next.
Deeply grateful.
Deposit the entire amount, Mr. Vijay.
5 crores and this thing.
5 crores and odd. Oh, unmute him, please. We can't hear you.
Been muted, my lord. Yes, my lord. Now I can speak, my lord. My lord, the order was for 3 crores, my lord. I have entire business
given you
as
extra
USA, my
time
lord.
till the end of September. Deposit the entire
Lord,
amount.
entire
Okay?
could not be deposited, my lord, because I have entire business at USA and because of Iran war, I am not able to get anything from there, my lord. Otherwise, I would have complied with the orders
What
passed
do
by
you
this
want to
honorable court.
deposit? How much do you want to deposit?
My lord, I will deposit. There is an order of 3 crores. I will deposit 1 crore.
Then you deposit by the end of August. That's it.
My lord, kindly make it by 15 September.
You can't play around. We'll dismiss your case.
My lord, kindly make it 15
Don't play
September, my
around
lord.
because of the
7 years.
Okay, the amount directed to be deposited as per our order dated so and so shall be deposited by 31st of August.
My lord, 15 September, my lord, kindly make it 15
The interim order shall stand vacated without reference to the court.
I'm deeply grateful.
My lord, could my lords make it till 15 September, my lord?
Next.
This is the matter with regard to the use of a crematorium, my lords.
Yeah, that's right.
There was an interim order saying that there should not be any construction on the crematorium. My lords, now the high.
We have filed a counter, Lord, and
We'll hear this and dispose it of.
this is an interim order.
Counter has not
Let the
come.
High Court decide the matter. The order has been there for the last about more than 12 years.
Post for final disposal. Counter is not come on record. Let the counter be taken on record. List the case for final disposal after 2 weeks. We'll dispose it off because it's an
Yes, absolutely.
It's interim order.
Yes, in the meantime, my lords, I'll file my rejoinder also before the next day.
Doesn't matter now. We will dispose it off. It's also coming on record.
Can I pray for a fixed date?
It's an email.
I'm sorry, Miss.
I said rejoinder, if any, in the meanwhile, after 2 weeks, we'll list it and dispose it.
Can I pray for a fixed date now? Because there's a crematorium not being.
All right. Next.
That's a business Sundara Beach in Lakes in court number 9.
We'll have it on some other day. It will take some time.
Next Friday, Lord.
Some Tuesday. Tuesday or Tuesday.
Again, let go.
It is related to the marking of secondary evidence, but covered by your lordship judgment. It takes time, my lord. Last time there,
Nobody is appearing, no?
Well, Revati Raghvani certificate is on, record is on, put it appearance. Some dates are very short point, my lord.
Yes, we
Whether I am covered or not, that's it.
We noted 2025 SCC 178.
Yes, my lord, that's all. Published.
Settlement is reached. I am the auction purchaser. They undertake before your lordship that we will pay 8 crores. They do not pay.
Who is appearing for the customer?
Nobody is appeared, Malas. And your lordship and service is complete, Malas.
No old matter what.
And Malas, till date, I have paid as an auction purchaser. I have paid Malas fully. They have undertaken.
What do we do? Raising your pitch. Nobody is appearing here. Relax now.
Yeah.
As if find out nobody's appearing.
Yes, Malas. The service is complete, Malas.
Put it up after services complete.
Service is complete, Malas. Office report says service is complete.
You take Dusty service now and file a Dusty.
Very good. Very good.
Then appears for the respondent. Counsel for the petitioner shall take Dusty notice and file a proof of service on the respondent.
Very good.
Lords, we are being led by learned Solicitor General in this matter. He is on his legs in court number 30.
37 delay on refiling delay.
My lord, it's a batch of matters. We'll prepare a list for each and every matter and place it before this court. The matter can be placed on Monday.
Sir, it's the delay is not of 350 days, it's only 142 days, right? We are asking you. Delay is not 350 days.
Please, it is 140 days. Please, my learned friend. Yes. Please, what has happened is that because the Tamil Nadu state police had a certain.
This thing, it has been dismissed only on the appeal, has been dismissed only on the ground of delay.
Yes.
On a premise that the delay is 350 days, whereas it is only 142 days.
Please, all that we are praying is that it may be sent back, please, because it was an issue pertaining to the stamp duty, please.
Don't let it be done.
Lordships, there are actually batch, your lordships. Mine is 40.21. It's not as against delay, your lordship.
Whatever is covered.
The delay is only 142 hours. We will condone the delay, restore the 37, ask the 37 to be disposed of expeditiously. Why should it be pending here? No, we will ask expeditiously.
Matter is not related to that delay, your lordships. That is what.
Okay, yours will be separated.
Yes, your lordship. Let it be.
How many matters are relatable? Actually,
My lord, last time and delayed. The matter will be taken up on Monday. We'll prepare a list and place it before the court.
Prepare a list and then tell
on
us
Monday
the delay.
we'll prepare.
Lordships, with regard to 40.21 alone, your lordship, it is not with regard to delay. It is the modification of the arbitral award based on an amicus query. The learned High Court judge had passed, your lordships. So let it be detached from this, your lordships. 40.21.
40.21.
My lords, if we can mark it till Monday, we are in 1,000 days. No,
Make a table
delay, my lord.
of each case. Indicate in that what is the delay and what the court has said. We will consider if there is an enormous delay, then we are not going to condone. Some marginal will condone it.
Yes.
It won't be there after 2 weeks.
In many cases, more than
no matter may be
delays are there.
No matter may be detached till Monday.
That one we will detect, sir.
Our directions are that there is a delay.
Our orders are, your directions
yes,
may be
I
something.
found out.
Then,
Any case of arrest in the same notification, they have paid the amount.
all right, sir. We are giving them a document to make a statement. Do that.
Obliged.
Grateful, my lords.
During the pendency before your lordship, the parties have been able to obtain a mutual divorce.
Dismissed as infectious in your statement of the policy for the petition.
I have obliged the lords.
Item 42. So this matter, I can propose a solution to your lordships.
because this is with regard to some allotments that were made, your lordships, by the DSIDC. Now, as far as the allotments are concerned, your lordships, considerable time has gone.
Scheme is in conflict with that. What is the solution you are
That
suggesting?
is DDA's appeal, mine is DSIDC appeal, where we had contested
How
that.
many matters are there?
Lordships, there are 3 matters. And in fact,
What are you suggesting? What is to be done?
What I'm suggesting, your lordships, is that as far as the conversion is concerned, your lordships, both DDA and I are on the same footing. The conversion has to be done. So, your lordships, let the conversion be done by us, your lordships, and then the amount that we get for the conversion fee, we will put it in a contingency fund. Because your lordships, this is going on too long now.
What suggesting is a good solution.
And your lordships, collect the ONGC judgment.
DDA has to answer.
This is between
I am
DDA and us. We can resolve this.
So we will adjourn it and then you tell us how you propose to do.
Very well. Next week, your lordships may keep it.
We will pick it up next week. You tell us in which manner you want to deal with it. Huh? Just give us a small affidavit. Huh?
Your lordships,
Or a note.
I can give after we've consulted and had our
All
internal
right, you give a
meetings.
proposal as to how it can be resolved. We'll make an order to that effect.
Yes, your lordships. Necessary at this
We'll
point.
keep it open if it is necessary after the solution.
It has also been discussed by the
After 2
High
weeks.
Court.
Next week and then next Friday for a proposal for next.
Very great.
Next week on, if possible on Monday,
Next Friday.
both of them will have freedom.
Malones.
Both of them have embraced freedom.
Have?
Yes, it's all settled.
Oh.
142 filed. Your lordship may grant the divorce.
Excellent.
This is 1975838.
We didn't know that. We didn't know that.
Yes, it's all settled. Correct.
We didn't know. When did this application come on record?
Came on record.
In fact, on the 22nd of July, and your lordships had permitted.
Please allow it in terms of the Anyway, good. This is what we were a little worried.
No, man. I think both council played a very, very.
All the matters, there are 2 matters which are pending.
All other matters will be withdrawn. It's all set out in the.
We'll make it a part of our order.
Deeply, yes.
And we'll dispose it of in terms of that.
Deeply. Yes, my lord will do that. That's automatic.
It's all good. Mr. Sibal, 1 minute.
Connected matter is against interim tables.
There's a connected matter which will also be settled.
Also be settled, Manoj. There's nothing left now.
They
can vote out.
44 directing to take instruction, only have it on next Friday.
41?
Lord, passed a order, Lord, where correctly we take instruction in respect of method, manner, and time. Have it next week.
All right. Next week में कर लेगा. Very good.
Well, this is that matter where we had filed a compliance compliance affidavit. Now they have they completely misunderstood the compliance affidavit.
No, you were supposed to take time to file an affidavit to indicate.
I already filed compliance.
So then what happened?
We have already converted the issue of compulsory retirement to golden handshake. We have offered to
So
pay.
then what remains?
Last time they disputed it and they wanted time to file a counter. They have filed a counter. They still say that it is a stigma of compulsory retirement. They still say that I want salary up to 2000.
You want to take the good 1 minute. What is it that you want to do? You want us to hear the matter and not accept that?
No, on that, my lord, I will just take 1 minute. On the compliance, it is not the way my friend
You don't
has
need
put
to
it.
argue it. If you are saying the proposal given by them by virtue of the affidavit filed, giving you a golden handshake, your client is not agreeable for that, then we will hear you. Just answer that question.
Yes, my lord,
You have every right to answer. We are not stopping you from saying. So therefore, that suggestion is not acceptable.
My lord, I will put it to my lords. My lord may ask them why it is not acceptable is they are only saying I was suspended from 15 to 17. 17 I was compulsorily retired. From 17 to 26 nothing has been considered. They are saying for those 2 years of suspension they will give me some extra money. It is merely 10 lakhs. That is the only grievance. If my lords may ask them to consider it in the entirety something better, I am okay.
Whatever my lord's direct, because he has not worked beyond 2017, we have.
You suggested the golden shake hand with 10 lakhs, is it?
10,41,000. We have already withdrawn.
That is only for 2 years of suspension period.
Wait a minute, sir.
What the suffering is
What is the
entirely for
period?
9 more years.
What is the period when he has not worked?
2015 to 17.
2015 to 17.
And 20.
And what happened on 17?
17, my lord, I was compulsorily retired.
So from 2015 he is out of service.
Yes.
My lord, but consider the unfairness of the process. From 17 to 26, all my suffering and hardship is because of that unfair process. Somebody wants
You
to
should only
push me
tell
off.
us. You should make a choice. You should make a choice. You go by their offer or not, or you will ask us to hear you and pass orders. You might succeed. Whatever, you make a choice, because last time you said some settlement we have suggested. You give a thought to it and then come back.
No, I'll just say it, my lord. If they are willing to consider, if it falls from my lord that they may consider some part of my 9 years hence also, then that is fine. Otherwise, I will argue it on merits. Because this 10 lakhs is very meager. It is.
How much do you want?
Lord, they may come with a calculation for the 9 years. I have an open mind on that. But say that I will not even consider the 9 years at all.
We are subjected to CAG audit. Whatever ex gratia payment my lords may deem fit, my lords may deny.
This golden handshake is like confirming my retirement.
You are getting confused, sir. Asking for a higher amount because this amount is lesser.
Yes.
But then you tell us, you may try and push it to them. You arguing merits and other things. It gives an impression that you want to argue and we are forcing it on you.
No. I am saying I will not. I may not put a number today. They may come back with a better calculation.
Why come back? We will ask them now itself. How much do you want?
Man, on that day, my lord, may pass it over. I will just check.
He has already withdrawn the entire gratuity and leave encashment. We are willing to give him pension also. He has opted for the wrong pension scheme.
Can we make it?
My lords may direct.
Take 20 lakhs and go. See, he straight away accepted.
Pass it over. I am not in a position to confirm that for my client.
Okay, all right, so pass it over. Next.
Item 46.
And these attempts, Lord. In fact, in the main petition, can I just finish it?
Please. Yes, absolutely. I'll come after.
Our problem is, Lord, that our contempt is not heard because of all the other people around us. So we are not
one by one.
It was hearing this matter on a so today I don't see the state here. There is a change in the panel. So if I may, it is state who has
for a very long time. Payment is actually closed.
It's just the
post for final disposal. Post for disposal on. Don't do it next Tuesday. Tuesday next day, then you'll hear all of you.
Yes, because your lordship had passed an order.
Pass it off. You know that. You know that.
The next. But our only request is the first contempt your lordship may hear, then everybody else may be heard, because they are all different, and therefore our interest is suffering only because
Do one thing, Mr. Patwalya. Matter is necessarily dragged on for such a long time. We will hear you. You first.
Yes.
Yeah. We are just telling you the backing order. Who is the main matter? Who is the?
I am there and my current friend is there.
My lords, we also have contents.
Lord, I'll be appearing for some of the unabsorbed
My lords, I
applicants.
need 7 minutes also, 10 minutes.
We will just for us. We will decide what to do.
Grateful, my lords.
That's all just four of you. Okay,
My Lord, I'll take 5 minutes, my Lord.
How could I dare to?
My Lords, I'll take 5 minutes, my Lord. I'm in 46.5.
Okay.
Not more than 5 minutes.
Anand, okay. Anand, all put together 40 minutes.
Grateful.
Yes.
All put together.
Yes, my
You're
Lord.
going to be very strict about it. This is actually unnecessary. Within half an hour, we should be able to wrap it
Yes.
up. Okay, Anand, just remember that nobody else will be heard.
Yes,
on
my
that
Lord.
day.
Yes, my Lord.
Yes, my lords. So grateful.
Grateful.
Right.
That's 4 of us.
Nobody, just one after another. 5 minutes, we'll wrap it up. Next.
Grateful.
Give a short note. We'll wrap it
Do
up
that,
fast.
don't do that.
Okay. All right.
Nothing, not necessary.
Ours is also a content. Ours is also.
No. Whatever we have filed.
All right, leave it.
We have said.
Yes, yes.
So great.
Item 47. This is that limitation matter. My lord, if you haven't filed a reply, I'm ready to argue.
Mr. Lordship, give us some time to file a reply.
Last opportunity was already granted.
It's time, we'll dispose it of next time.
Right.
Yes, things are, I choose to private.
My lord, just say last opportunity again because they've already been given a last opportunity in the registrar's board. My lord.
Audible. I appear for respondent number 7 in serial number 48. I filed my reply yesterday. It's probably not on record. I was requesting if your lordship.
Only issue of 617, my lords, no prejudice is caused to them.
No, my lords, if your lordships, may I just make one request? If your lordships could kindly keep it on any
What
day, I
is
would
there
like
to
to
argue so much?
physically.
Only amendment of.
My lords, kindly see the basis of amendment is that I gave this, I filed it with
Come
the
next week, we
plate.
will dispose it off.
Document is already on.
Could it be on 14th? Could it be on 14th?
We won't deny it.
Okay, because he's just said he's filed it. Next week, we'll dispose it off.
Could your lordships keep it on 14th?
No. Next, we'll dispose it off next week.
Monday.
Next, कभी अगले हफ्ते में ये Tuesday या Monday या even Monday Friday भी चलेगा ये ना इसके मत लगाना Monday Friday नहीं लगा
I'm being led by Learned SG in this matter. He's unavailable, the lordship. The lordship may have it on Tuesday if that is possible.
This Tuesday.
This matter, your lordship is yes.
Oh.
Number of orders, Mother Richard.
Learned SG is unavailable today.
Okay, next week
The arbitration is stalled. Arbitration is stalled, my lord. Your lordship told me orally, my lord. I told them to stay their hand because you don't.
No, we'll dispose it off next week.
Sorry, my lord.
We'll dispose it off next Friday. We'll put it up. All right.
Item 50.
You wanted us to admit this, but I thought we will dispose it off.
Whenever you
Not that question, huh? Interest on interest.
That's what they say in the recording to us. But whatever is the terminating date will be.
What do you want
It must be other than a miscellaneous date.
Other short order.
Lord, I am to the responding, but if your lordships feel can be admitted to the regular list.
Leave grant, appeal admitted. Hearing expedited. Hearing expedited. Next. Interest on interest. Please for the response.
Led by senior counsel, I'm seeking a short pass over minutes.
Moving the full direction of the.
He's requesting for a passover. Led by senior counsel, Mr. Gaurav Agarwal, my lords. Short passover.
49.
Item 50.
Have it on,
Your lordship, I am requesting a passover. Your lordship, in item 52, I am being led by a senior counsel. I am requesting a passover.
Hearing the counter has come, I'll file a rejoinder in the meantime. But there is the point of the NC 64. I can file a 2-page rejoinder.
Like the request of answer. 53. There's a letter there. As per the letter. Also 54. 54, there is a letter.
May I please, this that your tender man.
So my learned colleague make a okay, he permitted to make a request, another request for an accommodation for today. Malak may have it on Tuesday. I'm led by a senior.
Tuesday is difficult. We'll have it next Tuesday.
Wednesday,
Not this
Thursday.
Tuesday.
Could it-
Wednesday, Thursday, we don't take. Anyway, we take it up on Friday.
Any day after Friday.
Innocuous one. There's an IA 138328 for an implement because that party is essential. That's the certifying party. I just want notice to go on that IA.
Then we won't be able to dispose it of next Friday then.
Your Lordship. Your Lordship.
Saw who that applicant is, who that impleading party.
Isaka, who's the certifying authority, both sides. For
No,
both sides.
your Lordships,
CMMI.
if I may interject, your Lordships, I'm appearing for respondent number 1 for Nixie, your Lordship, the tendering authority. Your Lordships, in this case, what has happened is that the whole issue is with regarding to the CMMI certificate, because that is what the condition was. Now, if we allow this implement to happen, it a whole new different angle goes.
He's opposing it. Doesn't matter. We'll hear.
No.
We'll take it up on Friday.
On Friday, yes, because your Lordship is a very short issue. We will not
implement being allowed. I'm not saying implement to be allowed.
Yeah, that's
I'm
correct.
just saying let the notice go so that party can come.
Necessary for the present.
Yes.
We'll take
Getting delayed. My friend has herself written to that authority who are seeking to implement.
No, your Lordship.
They have written
Your
a letter
Lordships,
back
I need to address.
with a
I need to
response,
address on
which
this.
is why I believe that it's integral rather than me getting pushed off to a
Yeah.
later date. Your Lordship, remember there's that certification which they relied on.
Still not it. You do it once we apply our mind, Mr. Gopal.
So on that,
I would have.
Much.
I would
Your
have Friday.
Lordship, I'll address on
Any
this
other
issue
date
with
apart
regarding
from
to
5 days?
this letters, email also I'll address on
You can find a reply to the
Milots, any date apart from 5 days, Milots.
We'll put it. We'll not adjourn it for the next Friday.
Milots, any date apart from
We'll hear it on Friday. We'll consider at that date the requirement of it. Then we'll take a call on that.
I just thought that there's no mistake. She can also file a reply.
Your Lordships, that is not a necessary
Alright,
party
you heard
here
you.
because
You
it.
heard you.
Yes, your
Perfect.
Lordships, I'm not Friday. No, your
Milots, let
Lordships, I
it be next
apologize.
Friday, Milots. Humble
Friday,
request,
Friday.
Milots.
Much obliged.
I am existing since 2009. All I am requesting is let them accept my application, my fees, conduct inspection and decide for this year, not.
Sudhani, no, what is it? Today we are in the beginning of August.
No, the inspection of all the colleges is underway.
Because the deadline
For
expired.
which year?
For 26, 27. This is not sure.
This one. Classes would have started already.
No. Counseling, tentative date is 8th of August.
Why are you coming now?
No, please, this matter is listed on fourth occasion. So all I'm requesting is because 24, 25, my application remained pending. Now they say
Why
it was
did they go ask the High Court? Interim directions are given because of forest for
only election P15. Only P15 are moved.
Who said random college? It's
Because the deadline for application expired on the 8th of June.
That's all right.
Because there is a rule.
Are there? You're still counseling is happening in many cases.
Because counseling is happening, but the deadline for application has expired on the 8th of June. Because the whole application period, because this is going to throw the whole process into disarray.
Now kindly see P15
for 2 months. Because many new colleges will come now.
What delayed so much?
Kindly for a moment P15. Still P15.
Because
my friends say.
Wait a minute.
Because there is a rule, Milos. They are called the Manyata rules. Manyata rules provide for any reason, Milos, if the college does not have any admission or is not running a particular any course, Milos, for 2 consecutive years, you will be treated as a new college.
Recognition. The
Because they have-
pursuance of the interim order passed by the High Court, they have already applied.
Yes, because the order.
So then the issue in this SLP is whether it should be They're treated as an existing institution or a new one.
Yes, Milord.
Right?
Yes,
So
Milord.
what is your stand on?
Milords, the institution cannot be, Milords, treated under the rules to be an existing institution because Milords, the rules explicitly provide for 2 years, Milords, 23, 24, 24, 25, Milords, no admission. They were not running any classes, Milords. And Milords, there are many such colleges. Milords.
Okay, you withdraw this IA and go to the High Court.
No, in fact, why I have approached your
No, we are not going to do it.
Just one submission. Kindly have Lord's P15 for a moment.
So, Sal Khatam nahi hai. We can understand that.
No, what I am requesting is only
2 years there is a gap.
there is no gap. Why I am saying no gap? 23-24 was a 0 year for entire state. 24-25 we submitted application, notwithstanding that we are in existence since 2009. Every year we are seeking recognition. 2024-25 the application remained pending according to the rules on which my learned friend is relying. They have to convey the decision of rejection through email.
Yes. Round of CV inspection. It is completely wrong.
We are not inclined to interfere with the order.
What I am requesting, Your Lord,
They approach the High Court.
no, writ petition is pending, my Lord.
Yeah.
What I am requesting is
May approach the High Court by filing an interlocutory application for further orders. With which clarification, specific petition is discussed.
so one small submission that High Court may consider deciding
High Court may consider
before 8
on filing of application. High Court may consider
before 8 of
expeditiously.
before 8 of.
You move it. High Courts take up the matter every day, or you move it in the evening. Next day they come. You are acting as if you don't know how the High Courts function. What, Mr. Sherawat?
57 is a short issue regarding.
Well, in 57, I'm appearing for university.
Application, no?
No, there are some problems. I would like to know the losses will have it next week. I will have it.
My Lord, this matter, Your Lordship can.
No,
it should be clear, my Lord. Matter was listed on Tuesday. Did not reach. He was appearing. So he had sufficient time to take his second liberty.
It was better than me. Was what I have to do. That's amazing. Major problems.
All right, next week.
Next week.
Your Lordship may on Tuesday because the council.
Next week.
Please.
Don't make it infectious, huh?
Plus, there are major problems.
Don't make it infectious. Next Friday.
That's of the issue here. I've also asked them that how many more are there in the pipeline.
58.
Matter comes from after.
Yes, manpower sufficient.
Yes, I mentioned that in this matter, they have only implemented VICT and Windows. I agree for it. Now, the VICT doesn't have any rule. Apparently, the state which has been approved. Even if we send the state, they have not made part. So, there's a way we call the state party.
What do you want?
No, the state should be here because ultimately.
Serve it on the state. Service not made a party?
No, they have not made party. The state is not a party.
Yeah, he'll take
The
the
state has rejected their application. That is what my instruction.
Then he will suffer consequences.
State has set it. Timeline.
All right, forever. Monday. From today to Monday, what will happen? Nothing will happen. She's saying that. From today to Monday, nothing will happen.
In any case, there's not even. I mean, I would say my compound.
Yes.
Item 60.
Those items? 16. Yes, that's correction. It was not to be done. We did already. We are not going to do anything more. We just removed this line about C. That part needs coded up. C part of end करके order में end C last order में देखिए end C का the order passed by. I'll give it to you. The order passed by us on 21st July 2026 shall read as follows करके or in modification of our order dated. The order direction shall read as follows. I'll give it to you. In paragraph 2, and C to consider, open that up, or open that order. Take out the paperwork, open. Take it from him. I'll correct it for you. Okay, there's the. Because it was in the mentioning state, we didn't want to. We remember that, but we have rejected.
Otherwise, I'll use that.
Actually, you have not really interfered at all.
Something I don't control. After meeting mediation, after requirement, I get order.
This is item number
63.
Will it be appropriate for us to say that he can reapproach the APTEL for interim tariff to be determined? Will it be appropriate?
It's already an interim tariff.
Huh?
Yeah, there is an interim tariff
Which was originally set aside and refixed.
We have said it. We're just asking whether we are right or not. Appellant is at liberty to approach the APTEL for fixation of interim tariff during the pendency of the matters before the GERC, if necessary and if so advised. Legally, nothing wrong, right?
Legally, I cannot have.
I have only the right to consider.
In fact, not the GRC can dispose of the matter.
Because it's an interim.
That would be.
We got some regulations about interim. Thank you.
My Lord, I'm for the petitioner. Here, my Lord,
We have withdrawn the SLP.
My Lord, SLP was filed. Thereafter, I have come against the review order and the final order because the
Delay.
Delay, my Lord, because
17th of December 2019 is the appeal that you filed.
Yes, my Lord.
Correct.
My Lord.
And that is the appeal as against the sales certificate issued on 5th of November 2018.
Nice. Can I, my Lord?
Therefore, that is a hugely barred.
Explain, my Lord. Can I just explain? My Lord, can I explain, my Lord?
Whatever it is, there's a
My
delay.
Lord, just explain, my Lord. My Lord, what has happened in 2018, I cleared all my dues, that is 73 lakhs. Base 61 manifestly says that I have cleared all the dues. Thereafter, my Lord, suddenly they gave me a demand of 28 lakhs and tried to auction my property. I went before the High Court. High Court granted me an interim order and no sale certificate should be issued.
You know that.
Thereafter, my Lord, after the disposal of the
They said that avail your alternate.
Then I went
When
for
you
an
went.
MA.
But come what may, in an auction matter, the choice of going to the High Court and filing the writ petition was yours. In the meanwhile, somebody purchased a property in November 18. Today, even assuming whatever you have done on that date, today the situation is 2018 sale has become final.
My Lord,
And
that,
today on
my Lord, that
2026.
2018 sale, my Lord, is for it has been gone for rupees 73 lakhs. I had the entire thing has been calculated over there.
So what is that property?
Property is a residential house, my Lord, in the center of Cuttack city, my Lord. And its valuation is more than 3 crores. My Lord, kindly see page 61 for a moment.
2018.
Section.
Choices. You went when the auction was held actually in 2016 itself.
2016 was the first auction, my Lord.
Auction.
Yes, my Lord.
2018 it happened.
Again, my Lord, within that time period, I had cleared all my dues. That is reflected in that page 62, 61, 62. Absolutely, my Lord. This fact was given in the review petition and it has been overlooked by. And why?
The order, what happened?
DRT
Forget about auction, main merits of the matter.
Merits of the matter, my Lord. DRT, my Lord, condoned my delay, send it back to the DRT. As it was pending, my Lord, at that time.
Where is it?
DRT, my Lord, DRT order was passed, my Lord. My Lord, just. DRT order was passed in at annexure P10, my Lord.
It was
Recovery and the debt when the proceedings were initiated before the DRT.
DRT, my lord, I went before the DRT in an essay under section 17 of surface.
We are not talking about 17.
My lord.
You are talking about did you not challenge the recovery under the against your recovery of the amounts from you?
Then that was my lord, first I challenged it.
Therefore, there are no proceedings then.
My lord, essay
Only
was
recovery proceedings.
no recovery proceeding was there, my lord. Thereafter, my lord, in 2016 there was an option.
Very
I
well, sir.
filed a
Thank you. We are
securitization.
not going to entertain. Thank you. Dismissed.
My lord, kindly appreciate 1 minute.
Yeah, appreciate.
My lord, kindly see page 61
You
for
have
a
seen
minute.
it, sir. Thank you.
My lord,
Dismissed.
page 61 has cleared everything, my lord. Now
All
they
right, all
have a demand of 28 lakhs.
All
Right, 28 lakhs, my lord. The properties of valuation of 3 crores, my lord. Kindly appreciate that for a
All the
moment.
next, please.
My lord, kindly appreciate. Can I have more time to vacate my premises? Man, this is the only residential house, my lord, I have.
How much time you want?
My lord, 6 months at least.
Lordship, from the submission here, they may claim that the property is residential in nature. However, on physical verification by the
My lord, entire, my
You are
lord,
not right to liquor shop.
they have given
no, my lord, where they are getting all this thing, I
Yeah,
don't.
we can't trust you. Can't trust you.
Lordship,
We will permit you to go to the High Court. While we are not inclined to interfere with the order passed, the petitioner is at liberty to approach the High Court for granting extension of time for vacating the premises. To stop. We have given you time, or else we can't handle this contempt petitions filed by them for not recovery. Next.
item 16.
My lord, but one thing, my lord, can I just
T2?
Because I'm a candidate because in the reserved category as waitlist 2 in LLU Dachi belows. And here belows
Go to the High Court. Go to the High Court.
because there are 3-4 LLUs because they all following the same pattern.
No. Okay.
Because ultimately it's a violation of the constitutional mandate below.
Seeks to withdraw the petition under Article 32 to approach the High Court under 226. Permission granted. A writ petition is dismissed as well.
Because can your lordship just make a comment for expeditious taking up?
High Court may take up and dispose of the 226, the writ petition as expeditiously.
Item 63.
63.
Sorry. Not this raises not certain important issues. My lord, these don't seek to, my lord, upset.
63 will brief.
Yes. No, I'll just explain, my lord.
To relax minimum.
Yes, my lord. My lord, we don't seek to, my lord. Sorry. May I just explain? I'm sorry. My lord, the Lord, it will have all India, repercussion.
Every case.
No, my lord, just bear with me for 30 seconds, my lord. My lord, we don't seek to, my lord, upset any of the merit list. That's, my lord, out of the question. The only benefit which we are seeking, my lord, is that if the percentile is lower, then, my lords, we have an opportunity to either go to Russia or some other country to study medicine or come back and practice medicine, my lord. Now, what happens here is that the NEET exam, my lord, the original NEET exam got cancelled. Now, my lords, in the re-exam, my lord, there is an absenteeism of almost 12.27%.
We are examining in some other matter.
Yes, my lord. Lord, what I
withdraw this.
Lord, then may I make a request, my lord? May I make a request? Lord, I will withdraw this with liberty to approach, my lord, the authority.
Do whatever you want.
Lord, just may observe that. Because this doesn't affect, my lord, anybody. Let us, my lord, take a call on my representation.
What you want, don't fire from our shoulders.
I'm only saying that, Lord,
Dismissed, withdrawn.
only record my statement.
After some argument, Mr. D.el.ed Kamath seeks to withdraw the writ petition to avail alternative remedies.
To approach the commission.
Remedies, permission granted, dismissed as withdrawn. Next.
Password item 4.
Yeah, please, Malad. Malad, serial number 4 is squarely covered. I'm sorry, Malad, serial number 4 is Malad, squarely covered by the judgment of this honorable court in Mosul Beer, Malad. Now, what had happened is Provident Fund, Pension Fund, Gratuity Fund, all three are paid 100%, Malad. What remains is only the salary which will be paid as per 53, which has been rightly held by the NCLAT, Malad.
Now at this stage, how will it be? 67 of. At this stage, what can be done? Your use of
I'm for the respondent, Manoj. I'm so sorry, Manoj.
before CIRP process is what you're saying, and plan is all approved. At this
Correct.
stage,
It's
what can
implemented
be
also,
done?
Manoj.
Huh?
They are for the respondent who are arguing now. I have not opened yet. Let me open it.
Open it, sir.
So Manoj issued notice.
I'm so sorry, Manoj.
No, we thought there were similar matters that we were under the impression there were similar matters.
There is a share non-compliance with section 30 read with 53. It doesn't read any percentage business that has been held. It says amount. So the amount is really less. We have not even got peanuts. I would rather say peanuts, no peanuts.
IBC, what else will happen? The haircut is so much that one is only bald.
No, Your Lordship, but the haircut is so much.
But every whole IBC has become like that, unfortunately.
Yes, well, there is a waterfall mechanism which says you have to pay me first, the employees. And Manoj, kindly read section 30, Manoj, and bring the
What do you say now? Resolution plan is approved in 15th December 25.
No, Manoj, even the resolution plan was challenged till yesterday by the union.
Oh,
So
that's dismissed, Manoj. I'm so sorry. That appeal is
Yes,
dismissed.
Manoj, it will come back. Definitely union will also be there. So Manoj, it is not that it has attained some finality of some sort.
Which union is?
Union of India.
Manoj, some statutory, with due respect, some statutory dues were pending against that they have.
No, what to say is right. If a union is filing an appeal, we'll wait for some time.
That was a respect to very well.
It is dismissed yesterday, my lord. There is no appeal filed yet. It is dismissed yesterday by NCLED. That appeal has been dismissed by NCLED yesterday, my lord.
Definitely they will come. Union has.
No, this issue is covered in Mauser Beer, Manoj. Mauser Beer 1 para, this issue is clearly covered by that. They are the employees, not the workmen, Manoj. They come after the secured credit. Even the secured credit has not been paid in full. Only 13% of the secured
Nothing we can do. Item 5.
Please, Manoj.
Anyway, we are only adjourning for you to have a breather, but otherwise it's very tough.
Please.
Next. You are satisfied.
Yes.
Next. 45.
My lords, I have taken instructions. My lords may exercise the powers and direct us to pay 10 lakhs more. And we'll, apart from the 10 lakh,
No, my lord, I spoke to my client, my lord. He is saying that the same amount pro rata for the 9 years also they can.
Okay, all right, we'll hear you then. We'll hear you all to the case. We might discuss, don't tell later on that no, give me money. We are just telling you, you are under this. We are hearing you. Yes, thank
Try to counsel my.
whatever it is. You are under no obligation. You have a right to argue.
Then my lord may enhance it. I will leave it to my lord.
No, you take it. There's no force on you.
No, it is not on for my lord. He wants the resolution. That is the only reason.
Affidavit there.
My lord may enhance it, my lord, to some. I will leave it to my lord.
Especially petition is against the judgment and order. The petitioner worked as an administrator and finance officer in Maulana Abdul Kalam Azad Institute of Asian Studies on the basis of a complaint by one Priyanka Basu, the personal secretary of respondent number 3, who was the director. One Priyanka Basu, personal secretary of respondent number 3, filed a case of sexual harassment against the petitioner. The director placed him on suspension with 50% subsistence allowance, and later on a charge sheet was filed against the petitioner, also on grounds of insubordination and lack of integrity. Full stop. The petitioner filed a writ petition challenging the above action, in which he has also questioned the action of respondent number 3. The writ came to be dismissed. Thereafter, respondent number 3 directed that the petitioner should be compulsorily retired. Past orders directing the petitioner that should be compulsorily tracked. This action was challenged by the petition. The writ petition, which came to be allowed by the learned single judge of the High Court. In the said order, the single judge also made certain observations as against respondent number 3. Respondent number 3's writ appeal came to be allowed by the division bench of the High Court, and the present specially petition is therefore against the said order of the division bench. We, as a pending disposal of specially petition, we requested Mr. Swarnendu Chatterjee, learned counsel appearing on behalf of the respondent, if the petitioner has served the institution for a long period, commencing from 2/4/2009 to 6/11/2015. After taking instructions, Mr. Swarnendu, who affidavit has filed an affidavit indicating that the respondent who is taking this golden handshake? No, not petitioner. Who are you?
I'm for respondent number 2 and 3.
Respondent. Who is that?
The institute and the chair.
Abdul Kalam Institute has filed an affidavit. What did you say? What did you say? Filed an indicating
has filed a compliance affidavit.
Compliance affidavit on behalf of respondent number 2 and 3, extending an offer of golden handshake. Relevant portion of the affidavit is as under. Which is the paragraph you want us to extract, Swarnendu?
Malaj may extract the office order, which is at page.
That's better. Okay.
A1.
The office memorandum issued on the basis of the said affidavit, pursuant to the said affidavit, is as under. Paragraph, having considered the matter in detail, you are of the opinion that interests of justice will be subserved if we direct the respondents to pay an additional amount of 10 lakhs, full stop. The appeal, in view of the above, the judgment and order passed by the High Court is set aside. The petitioner, the appellant, the appellant is
My lords may dispose of the writ petition in accordance.
Dispose of High Court process.
My lords, rather than setting aside the division bench order,
yes. You are right. The appeal is disposed of in terms of the consensus arrived between the parties, as reflected in the office memorandum. To receive the amount as indicated in the office memorandum and the additional amount as directed by us, totaling 20 lakhs 14,141,000. This said amount will be no further claims. No further groups. How much time will take?
May I make one request?
My lords, 8 weeks, 12 weeks. My lords will give 12 weeks.
My lord, may consider granting some interest also. This is pending from 17.
No, that's enough.
And my lord, his PF has not been withdrawn, I am told.
Can withdraw the PF.
Without any further claims, stop. The said amount shall be paid within a period of 6 weeks.
8 weeks.
8 weeks from today.
Regarding the
One line also
for the clearer of the issue, my lords, he has opted a wrong pension scheme. he should, that's what a part of the compliance affidavit. He has to come to the office of respondent number 2 institute for correcting the papers.
Or else you will not get pension.
Yes, I'll do that.
Let's make it a part of the audit. Otherwise, we file another.
The appellant will visit the office of the respondent for making the necessary corrections with respect to making the necessary corrections.
For grant of, for enabling the grant of pension.
और then for grant of pension वो है ना वहाँ पर देख लेना वो पैराग्राफ में लिखा है उसी में.
My lord, may also observe the PF point, my lord. Otherwise, it may not.
For even final settlement, my lord, whatever.
My PF for the duty that I have done, that is left. My PF for the period that I have worked, I have not taken that.
Anything.
My lord may just mention that. Otherwise, again, they will create. It may create some obstruction. That part is not in dispute also.
The provident fund.
That is the root.